Right. And you're
The chair,
recording.
the chair notes the appointed time is 6 p.m. and I call this meeting of the Amherst Zoning Board of Appeals to order for Thursday, July 23rd. My name is Everald Henry, Chair of the Amherst Zoning Board of Appeals. I want to welcome everyone to this meeting. We will begin with a roll call of the ZBA members. Mr. Sloviter,
Here.
Mr. Offeld,
Here.
Mr. Meadows,
Present.
Ms. Morton.
Here.
The chair knows that a quorum is present. Also present tonight is Mr. Jeffrey Bagg, Planning Director with the town. Pursuant to Chapter 2 of the Acts of 2025, extended through June 30th of 2027, the ability of public bodies to meet in a fully remote or hybrid manner, this meeting will be conducted via remote means. Members of the public who wish to access the meeting may do so via Zoom or by telephone. No in-person attendance of members of the public will be permitted, but every effort will be made to ensure that the public can adequately access the proceedings in real time. The Zoning Board of Appeals is a quasi-judicial body that operates under the authority of Chapter 40A of the General Laws of the Commonwealth for the purpose of promoting the health, safety, convenience, and the general welfare of the inhabitants of the town of Amherst. One of the most important elements of the Amherst zoning bylaw is Section 10.38. Specific findings from this section must be made for all of our decisions. No decision is final until the written decision is signed by the sitting board members and is filed in the town clerk's office. Once the decision is filed with the town clerk, there is a 20-day appeal period for an aggrieved party to contest the decision with the relevant judicial body in the Superior Court. After the appeal period, permit must be recorded at the Registry of Deeds to take effect. On tonight's agenda, we have ZBA FY 2026-19, 27 Newell Court. This is an appeal of the Building Commissioner's May 4th, 2026 and May 12th, 2026 determinations and refusals to enforce protected ADU gross floor area calculations pursuant to Section 10.1 Appeals and Chapter 40A, Sections 8 and 15, pertain to Sections 5.011 and 11.41 of the Amherst zoning bylaw. Chapter 40A, Section 3 and 760 CMR 701.00. Said appeal pertains to 27 Newell Court, map parcel 14B-8, RG zoning district. Also on the agenda tonight is ZBA FY 2026-21, 112 to 114 North Whitney Street. This is continued from July 9th for request for special permit to change the use from a 4-unit building to a non-owner occupied duplex under Section 3.3211, a non-owner occupied duplex, an expansion of pre-existing non-conforming structure by enclosing an existing front porch under Section 9.22. Said property is located on map parcel 11D-150 RG zoning district. As always, we'll have general discussions, a public comment period, any other business not anticipated within 48 hours, and we'll adjourn. The first order of business is the appeal ZBA FY 2026-19, 27 Newell Court. As a matter of clarity, on the PAR, it stated how the order would be. The commission would present first, then the applicant would go, then the appellant. Given that this is an appeal, typically in an appeal process, the person who's appealing has the burden. They usually go first because they bear the burden. The building commissioner, I would suggest, would go second, given his decision, and the applicant can also present. Again, this is an appeal as opposed to a special permit request. So for time-wise, each party will have 15 minutes for the presentation. That 15 minutes includes any rebuttal that may be made, and so be mindful of your time when you're doing rebuttal. When you are presenting, as well as how much time you want to reserve for rebuttal. So again, each party gets 15 minutes. Within that 15 minutes, you can reserve some time for rebuttal. Each person gets one rebuttal. The appellant goes first as they bear the burden. The building commissioner will go second, and the applicants will go third. After which, we will have comments and questions from this body, as well as any public comments on the appeal. Before we open the public hearing, Does anyone on the panel have anything to declare or disclose? I see no answers in the affirmative. So, Mr. Bagg, given that there are no disclosures, I will open the public hearing and begin by reading into the record the submissions. There has been a significant amount of submissions as well as public comment. Some town staff has been very busy, so forgive us if everything is not read into the record, but they will be available on the town website. So the applicant packet, application form filed with town clerk on May 15, cover letter dated May 15, 2026, Exhibit A, B, C, D, E, Exhibit F, Exhibit G, Exhibit H, Exhibit I, Exhibit J. Those exhibits ranges from the building permits, the first floor plan, second floor plan, gross habitable space drawing, building plan, email exchanges between Noah Kuhn and building commissioner on May 4, 2026 and May 5th, email exchanges between Noah Kuhn and building commissioner on May 8, 2026 and May 12, 2026, email exchanges between Noah Kuhn and building commissioner on December 17, 2025 and December 18, 2025, email exchange between Molly Strehorn and inspection services between December 2025 and December 22, 2025. Exhibit J is relevant legal citations. From the town materials, we have written extension agreements between the ZBA and the applicant, the zoning bylaw excerpt, section 5.011, article 6, 11, and 12, 760 CMR 71.00. And as of July 17th, we had public comments. Michael Pill, later dated July 12th. Ira Burke, email dated July 13th. Killian O'Connell, email dated July 13th. Yupan Zing, forgive me if I pronounced that name incorrectly, email dated July 17th. So with that, so as a matter of background, the town of Amherst worked through 2025 on amendments of the zoning bylaw to meet the state's updated ADU regulations. Ultimately, the amendments to section 5.011 were adopted by town council on November 17th and became effective on the new bylaw December 1st, 2025. The new zoning allowed two types of accessory dwelling units, summarized as follows. Protected ADU, which complies with Chapter 40A, Section 3, and 760 CMR 71.00, which is allowed as right, no owner occupancy requirements, and contains no more than half the gross floor area of the principal dwelling, or 900 square feet, whichever is smaller, as well as other requirements in section 5.011. A local ADU, which is allowed by administrative approval, requires that one unit must be owner occupied and is larger than a protected use, but contains no more than 1,200 square feet or gross floor area, as well as other requirements in section 5.011. In this case, a building permit for a protected ADU was issued on December 18th, 2025. The appeal is not of the building permit, rather, it is of the subsequent written determinations of the building commission issued on May 4th, 2026 and May 12th of 2026. That is the nature of the appeal. And with that, Mr. Bagg, if you can just please invite Mr. Kuhn as a panelist.
Yep, so that's been done. So, Mr. Kuhn, you should be able to unmute and turn on your camera if you wish.
And as a matter of policy, before speaking, please introduce yourself and your address for the record.
My name is Noah Kuhn, and my address is 9 Newell Court. And may I share my screen to show some additional information while I speak?
Yes, you can.
All right. Good evening, board, Mr. Chair. I am the appellant, Noah Kuhn. My property at 9 Newell Court directly abuts 27 Newell Court, and both properties take access from the same private way. This appeal presents one narrow question, but how the board answers it will determine whether Amherst's 900 square foot ADU cap can be enforced as written. Can finished upper level dwelling space be excluded from a protected ADU's gross floor area by calling it an attic? The town determined this ADU contained 891 square feet of gross floor area, or GFA. Yet the approved plans also show a finished upper level with 2 bedrooms, a bathroom, closets, and stairs. The plans identify the 2 bedrooms alone at 290 square feet before counting the bathroom, closets, and stairs. None of that finished upper level space was included in the town's GFA calculation. After I requested a zoning determination, the commissioner concluded in writing that the ADU proposed and under construction at 27 Newell Court does not comply with the ZBL because it is too large in square footage to be considered an attic. The May 14th amended plan then reported an attic area calculation of 296.85 square feet, exactly 0.15 square feet below 1/3 of the 891 square foot first floor. That change appears directed to the upper level's story classification, but even if it resolves that classification issue, it does not answer the separate zoning GFA question before this board. Changing the knee wall dimensions can change a building code classification, but it cannot make bedrooms, a bathroom, stairs, and circulation space disappear. Under that interpretation, nearly 297 square feet of finished living space sits outside the 900 square foot GFA calculation because it falls 0.15 square feet below a story classification threshold. Amherst GFA definition includes stories of compliant ceiling height, lofts, and intermediate floored tiers. The excluded categories are crawl spaces, garage parking areas, enclosed porches, attics, and similar spaces. I agree that the unfinished roof cavity above the ceiling and the eave space behind the knee walls may be excluded. Those aren't the subject of this appeal. The finished residential space inside those boundaries is. The owner's comments now confirm that the upper level is additional living space. The question is whether that finished living space falls within the attic exclusion. This is the central issue. What does attic mean in this GFA exclusion? Amherst does not define it, so the word must be read in context. Crawl spaces, garage parking areas, attics, enclosed porches, and similar spaces. The building code reinforces that distinction by defining attic as unfinished space and separately defining attic, habitable. Section 6.18 classifies floors and stories. It does not say that habitable attic space is excluded from GFA. These plans show 2 bedrooms, a bathroom, and circulation space. This is not the kind of attic this exclusion describes. This appeal isn't just about one ADU. Whatever interpretation the board adopts tonight will guide how applicants and staff apply this GFA limit in future cases. If this interpretation is upheld, applicants can add substantial finished upper level living space while continuing to describe the ADU as an 891 square foot structure for zoning purposes. On timeliness, I appealed the commissioner's May 4th and May 12th written enforcement responses within 30 days. In December, I asked whether the permit had issued. The commissioner said he would check and understood that it was ready to be issued after DPW review, but I received no later notice. The public record identified an 891 square foot ADU, and an abutter who requested the plans received only a plot plan. When framing disclosed the upper level, I promptly requested enforcement. The town's May 12th permit record then stated that the permit does not incorporate the additional living spaces shown on the second floor plan and required a revised plan and permit modification. The amended attic floor plan did not exist in December. Those are the facts supporting timeliness. On standing, my property directly abuts 27 Newell Court. Both properties use the same private way, and the ADU is plainly visible from my property. The challenge interpretation permits additional finished residential floor area and intensity beyond the protected use ADU limit immediately adjoining my property. Those are site-specific effects, not a generalized interest in zoning enforcement. I respect the commissioner's role, but this board is the body charged with independently reviewing his zoning determination. You're not supervising construction, you're making a threshold zoning determination. Unfinished attic and eave space may be excluded. Finished upper level dwelling space of compliant ceiling height designed for daily human occupancy must count toward protected use ADU GFA. The building code answers one question, Amherst zoning bylaw answers another. Tonight, you're being asked to decide the zoning question. I respectfully ask the board to determine that finished upper level dwelling space count towards gross floor area and to reverse the commissioner's determination to the extent it concludes otherwise. Thank you.
Thank you, Mr. Kuhn. If I may, the GFA exclusion groups attics with crawl spaces, garage parking areas, and enclosed porches. Why should attics in that list mean only unfinished space rather than any space under a pitched roof?
Well, when you don't have a definition, you have to take the context for what the word is by what it's surrounded with, and especially with the and similar spaces at the end of that line. Those spaces are transient spaces. They're not meant for habitable, heated living spaces. I know that there's a legal term for that. I'm sure you know it. But yes, that's the position.
And in looking at sheet P3 itself, it distinguishes finished subfloor bedroom space from areas noted as having no subfloor behind the knee walls. Does your position require counting of upper level space or only the finished subfloor portions?
Only the finished portion in the center. I believe that the space above the ceiling and in the eave areas, that is what should be intended to be excluded, and I take no issue with excluding that space.
I'll yield questions to other members of the ZBA for Mr. Kuhn. The chair recognizes Mr. Offeld.
Mr. Kuhn, thank you for your presentation. You've shown us a revised bedroom plan, which is less than 300 square feet. I forget the number. Is it your understanding that that bedroom plan satisfies the current bylaw? Are you suggesting it does not, or it does?
I suggest that it does not, due to the fact that it is finished living space and it is not an unfinished attic, which is what the exclusions are referring to.
Okay, and that's the revised bedroom plan, not the original bedroom plan I'm speaking to.
Correct. The
Okay.
original building plan was larger, and when
Right.
the commissioner reviewed that after my requests, he determined that it was too large to be considered a habitable attic. I believe the building code says that a habitable attic must be less than 1/3 of the floor space below. So the redesigned version where the knee walls were moved in is 0.15 square feet less than that threshold. And in the building commissioner's opinion, makes that an attic that is no longer counted towards the floor area of the building.
Thank you, Mr. Offeld. The chair recognizes Ms. Morton.
Hello. So I believe I read that the definition of the floor area had to be measured from the inside of the exterior walls. And if you were measuring from the inside of the exterior walls, would you not have a larger square footage than what is shown on the revised plan, because it would have to include not just the bedrooms, but the basically all of the finished space on that upper level.
Are you referring to the first original plan?
I'm referring to this, even the second one, that, well, both of them don't include all of the space on that upper floor that's inside of the exterior walls, which is
Uh,
what was listed as being the definition of the gross square footage.
Correct. I guess the issue is the attic exclusion. So I believe that the eave space and the space above the ceiling of that finished space is a true attic, unfinished attic, and that is eligible to be excluded from that calculation.
Right. But I think even the revised plan only showed the square footage of the bedrooms and did not include all of the finished square footage of the upper floor.
As far as I can tell, the calculation was accurate, except that they did subtract the stairway. Um, I can't speak to whether or not that is the correct way of determining a stairway, because it is technically within the interior walls. That would, with the inclusion of the stairway, that would put it over the limit.
And the stairway area is included in the measurement for the first floor.
That's correct.
So I would say that sounds like it's inconsistent. I was just asking for clarification to see that I was seeing it correctly.
Yes, that's my understanding.
Thank you.
Thank you, Ms. Morton. Mr. Kuhn, what measurable particularized harm do you expect at 9 Newell Court from this ADU's current size, as distinct from a general interest in seeing the bylaw enforced?
Well, we share a private way for access to both properties. It's a gravel road. There is currently another rental property on that property. So the traffic to and from this building will increase the intensity of use of that property directly adjacent to my property. We maintain the road together. So yes, that's why.
Thank you, Mr. Kuhn. Are there any other questions from members of the board before I invite Commissioner Mora? Mr. Meadows?
I think one point that you basically just made, Noah, is you have a young child. Is that not correct?
I have two, yes.
And are there sidewalks on Newell Court?
There are not.
And therefore, your children are in the road or going back and forth on the road, are they not?
To access Taylor Street, that's correct.
So if you had essentially 4 bedrooms additional beyond what there is now, that'll increase the traffic and make it more difficult and dangerous for your children, I would assume.
I think that's a reasonable thought.
Thank you.
Thank you, Mr. Meadows. Mrs. Silver, any questions for Mr. Kuhn?
No, thank you. Not at this time.
Thank you, Mrs. Silver. Mr. Kuhn, thank you for your presentation and answering our questions. The chair recognizes Commissioner Mora.
Thanks, everyone. Rob Moore, Building Commissioner. Mr. Bagg has a few slides that he'll put up for me as I talk through some of the key points of this discussion. And we can skip the background slide, Mr. Bagg. I think Mr. Henry covered that in his opening remarks, and we can go right into the third slide.
Yep. Just give me 1 minute here.
And as he's bringing that up, I'm going to talk about definitions in the bylaw, key sections and definitions of the gross floor area. As you know, it's defined both in the state law and in our local zoning. Exact language was carried over from the state regulation into our zoning bylaw amendment. I'm going to talk about story and half story, and I'm going to talk about habitable space. So starting with the gross floor area that's up on the screen almost. The sum of all areas of all stories of a building. That's important because we're going to talk about stories in a moment. And as you've heard from both the introduction and Mr. Kuhn's presentation, is that this language in this definition excludes attics among other spaces. I will mention, I might repeat this again at some point, that nothing in my discussion or determination or part of the May email exchange includes a determination related to the building code. This is all about how we interpret and apply our zoning bylaw. Discussion and interpretation of building code is something that wouldn't be in front of the Zoning Board of Appeals. And I will mention that as we talk about some of these excluded areas, it will become clearer when we understand how the zoning bylaw defines habitable spaces, which can include a lot of spaces that may not be traditionally thought of as living spaces in a dwelling unit. We can go to the next slide, Mr. Bagg. So story and half story are relevant pieces of the bylaw for making this determination about attic. This language was added to the zoning bylaw in 2013 and helped to help us determine what number of stories might exist in a particular building. And that's, as you could imagine, very important when we have limits on the number of stories. We have 2.5 story buildings in certain zoning districts. We have 3-story buildings in other districts. So these upper floor areas will be critical to understand what they are and whether or not they count as a story to ensure that the property is in compliance or the building is in compliance. In this first definition, the story definition, simply it sends us off to the building code, as you can see in the highlighted in the bolded language. So I don't think there's much to talk about related to what is a story. It's going to be about the half story. And as you see in that first definition, in the second clause there, other than a half story in the top floor with attic in parentheses or basement, what we've essentially done is we've equated the top floor of a structure as an attic. So we've made that connection in this definition here. And I believe that was intentional, as I understood, as this bylaw amendment was being produced in 2013 and introduced into the bylaw. At that time, the new language in the second definition here for half story, creates this unique term that doesn't really show up any in building code. It doesn't show up in certain bylaws. It really is unique to us because we have a zoning district that has a half-story allowance. So a half story here is the habitable space. So everything we're talking about, whether it be full story, half story, attic space, includes habitable spaces as we define it. And we'll get to that in a moment. But the half story in the top floor of a compliant ceiling height, and the last part there that's bolded, no less than 1/3 of the habitable floor area of the full story below. And I think, as you heard in Mr. Kuhn's presentation, that, I do believe this was intentional because there is an alignment with building code on the 1/3 determination, making 1/3 of the space the factor that determines whether or not it's an attic space or whether it's a story. I think that was intentional to try to reduce conflict between zoning bylaw and building code. But what we have here is we have a floor that is a half story with more than 1/3 of its habitable floor area. So in order to be the half story, it has to have more than 1/3. What happens to the 1/3 or less, or less than 1/3? That's the remaining piece here. And our way of applying this, our understanding of this section as it was written, its alignment with the building code, was that anything less than 1/3 is the attic, as it's referred to in the first definition as the top floor space, but it's not a story, it's not a half story. What is it when it's the small space remaining? It's an attic. Next slide, please, Jeff. So what we take from general meaning of the term attic is that it's underneath a roof line, within the volume of the roof. So we're not looking at a space that's totally surrounded by walls. That would be the primary floor, first, second, or so on of the building. It can be finished or unfinished. There's absolutely nothing in our zoning bylaw that states otherwise. We refer to habitable space when we're measuring the attic space. Habitable space, as you'll see in a moment, can be storage spaces, it can be bedrooms, it can be bathrooms. That is very different from building code. So there's no connection there. Building code would actually exempt bathrooms, exempt closets, and make these floors bigger. So we want to be careful of that. And I don't want to use definitions in the building code because it actually would allow the square footage to be bigger. And in fact, what you learned a few moments ago from Mr. Kuhn is that the difference between the two plans that were presented, with one being larger and then one being corrected, was the method of measurement. The designer used the building code to measure the first set of plans, and the second set of plans was corrected to be accurate with the way we define habitable spaces and include more area in that measurement, as a result, making the usable finished area smaller. So the space has to be smaller than the half story as defined, has a compliant ceiling height of less than 1/3 of the area below, and the measurement is taken using our habitable space meaning. Thank you, Mr. Bagg. So this is our definition out of the bylaw, Article 12, the gross square footage of the enclosed interior space. This has remained unchanged for many years. As you can see in the bold, I'm just pointing out that it includes all of these spaces. So we could have a upper floor area that gets defined as an attic, but is completely unfinished, open stud, could be storage, could be used for some other purpose, not bedrooms, not bathrooms, and it is still habitable space. It could be turned into bedrooms, it could be turned into a art room, it could be turned into any other type of use, and generally qualify as a habitable space according to our zoning bylaw. And this is used, and it was used previously with our accessory dwelling unit definition, but is no longer available in the gross floor area meaning. Next slide, please. So this is just to illustrate how we look at the stories. Hopefully it's helpful. This is just showing what would be traditionally down at the bottom, underground perhaps, or partially underground, a basement or a crawl space. What determines one or the other is going to be the ceiling height. The basement has a minimum ceiling height requirement. Anything less than that, by definition, would become a crawl space. This particular illustration shows 3 full stories, and then the upper level there would either be a half story or an attic, depending on the measurement that we talked about a little while ago. The area outlined in red, if you can see that up in the triangle on the gable end of the building, that's the space that would be considered either a half story or an attic. If it's 1/3 or greater, it's a half story. If it's less than 1/3 of the floor area below, it's an attic space. Next slide, please. This is the section view, the cut through of the plan for 27 Newell Court. Again, similar to the last image, we've got a lower level underground that they've built as a crawl space. We've got a first floor, the 891 square feet, and then we've got the space up at the top, which is the attic space. Now, as corrected, is less than 1/3 of the 891 square feet below. Next slide, please. I wanted to mention that this is not at all a surprise to me. This particular issue about attic space, the kind of awkward way we have to use and identify basement spaces for the measurements, the lack of habitable space as a way to determine these square footages, and other parts of the state law were realized very early on. We talked about it in great detail a year before this permit was applied for and ultimately issued. We did, make efforts and presented comments during the public hearing process for the state law changes. And as a last, I think, measure, it was just a couple months before the bylaw went to its final vote. If we looked back at those drafts, you'd see that we actually kept habitable space in the definition of gross floor area. We changed the gross floor area definition from the state law to leave habitable space in there so that we wouldn't have these conflicts, that we wouldn't have these questions. And we asked the AG to consider that and give us comment back before we went to vote, and we never received a response to that. However, we were monitoring the AG's decisions for other towns across the Commonwealth, and the use of habitable space in the definition of gross floor area was stricken out over and over again, disapproved in many other communities. So ultimately, we decided to remove it. When that happened, we discussed this in the final stages of the bylaw amendment process, and it was discussed several times during that time. So that takes me to just the last slide here. Floors and stories are measured the same way for both ADU types, so protected and our local ADU types that Mr. Henry outlined earlier. This attic space exclusion would apply to both of those. And as a result, as odd as it sounds, the habitable space, actual living space of a dwelling unit can be larger than the gross floor area. I would like to just, if I have more time, Mr. Henry, I would like to address one of the comments I heard earlier about stairway. Whether or not it's included or not included. And this is for a very long time in building design and measurement, always been an interesting question and discussion. But what we have done consistently and for a very long time is count the stair once when we're measuring buildings for square footage. It is not floor area in the first floor. There's an opening in the floor area, and the stair is below the floor of the first level, part of the crawl space. So the stair that goes up to the second floor or the upper level or the third level, that would count on each of those next levels once. So we're not counting that floor area twice. All of this, when we're talking about square footage and area, is the measurement of the floor area. It's not the volume of the space. If there's a large open foyer when you walk in the front door above you, that's not floor area. That's not counted in square footage when we're making these determinations. So I just want to make sure that that we're aware of that. And if there's any questions, happy to address that. One last comment about habitable space. And the relationship to some of those other exceptions. A three-season room, an enclosed porch and a deck is a very much a habitable space. It's a very usable space. I don't understand that exclusion either in the state law, but it is, just another one of those items that we have to deal with and have to make adjustments for and consider when we're reviewing applications. And once again, just finally, to repeat that, nothing I spoke about here other than drawing relationships in certain areas, is basing these determinations or the application of our bylaw on anything in the building code. Thank you.
Thank you, Commissioner Moore. If I may just start with some questions, and as a matter of clarity, so between your May 4th determination finding the ADU compliant at 891 square feet and your May 12th determination finding it's too large to be considered an attic, which is your operative position tonight, and what specifically changed?
So the building permit was issued based on the data that's put into the application. It's an online permit application. The applicant inserts the square footage and that gets reviewed. The plans get reviewed for building code compliance, energy code compliance, and ultimately the permit gets issued. Now, I don't review the permits. I don't issue the permits. So I can't explain exactly what happened in that case. When it did come to me through Mr. Kuhn's questioning, and I looked at it closely and went out and looked in person at the ADU, I believe what I found was that the attic space was designed and calculated by the designer using building code methodology rather than relying on the habitable space definition in our local zoning bylaw. And I asked for the adjustment to be made.
So is your position tonight that the space is too large to be considered ADU?
My position tonight is that the space that is shown on the amended plan and ultimately constructed, because I returned after it was constructed to make sure that it was built according to that new plan. My position is that it is in compliance now.
It is in compliance now.
Yes.
Okay. And if I understood you correctly just now, so even if an attic gets built out, bedrooms, bathrooms, the classification doesn't change. Regardless, it still remains an attic, and that is not counted in the GFA.
That's right. As long as it's an attic, the attic would be excluded.
Okay. And if the board finds that the second floor bedroom space must be counted, what is the corrected total gross floor area for this ADU, and does it exceed the 900 square feet requirement?
If I understand your question, if the board determines that this upper level is not an attic, then the two square footages would be combined for the gross floor area.
And that's where I saw
the 891 and the two, I don't have the number in front of me, but the 290.
Understood.
Those two numbers would be combined.
And you can correct me here, but I think I saw something that said this particular design has been permitted multiple times. To the best of your knowledge, how many other Amherst protected use ADU permits use the same attic exclusion approach? And has any other been the subject of a similar enforcement request?
I believe there were 9 total. And as a result of this questioning that Mr. Kuhn brought forward, my office reached out to each of those permit holders to ensure that the plans were in fact either updated or accurately designed to the habitable space threshold of our bylaw. And I believe all the corrections have been made. What we did was we put a hold on every permit that had this situation until the corrections were made, and then the permits were released at that point.
And just as a matter of clarity, is there a cease and desist order in effect for the property, or is it still work still being done?
There is no cease and desist on any ADU project, and this property does not have a stop. It does not have a hold. It did for temporarily have a hold while we were both making sure we knew what we were asking for after reviewing this, getting in touch with the owner and asking the owner to respond and make the corrections, and they did so immediately. And there was no need to, go to the cease and desist formal enforcement.
Thank you. One of the provisions in the bylaws, 6.181, which defines of a habitable half story in a top floor, as well as GFA 5.0112A. And I can appreciate if you don't know those numbers outright, but do you read the bylaw 6.1A1 definition of habitable half story in a top floor as governing whether the space counts toward GFA area under 5.0112A, or are these two independent bylaw provisions in your view?
In my view, if I found that it is a half story by that definition in 6.18, it would count in the gross floor area. If it was over, if it was 1/3 or larger, as it must be to be a half story, then it would count.
Okay, but as of your testimony, it is still adequate definition.
Because the adjustments were made and it is no longer 1/3 or larger, it is less than 1/3, it is no longer a half story.
Okay.
Therefore, an attic and excluded. When I made my initial visit and looked into this at Mr. Kuhn's request, I found that it was in fact a half story as designed and as in one case constructed. And that's where the hold was put on the permits, and the owner was advised to find a way to bring the project into compliance, and ultimately they chose to make the floor, remove the floor, and remove the walls and rebuild it and redesign the other properties permit applications to come into compliance with what would be an attic so that it could be excluded.
And one final question before I turn it over. Sheet P3 notes no subfloor behind knee walls, ceiling joist, and insulation only in the eave areas, distinct from the labeled bedrooms and bathroom. Does that distinction affect your gross floor area determination?
It doesn't. So it wouldn't make any sense to talk about gross floor area if there wasn't a floor. There has to be a floor. It can't be above a ceiling. It can't be hidden behind walls that you can't access. The exclusion would have no meaning. The other items in the exclusion are places you can stand. You can stand on a crawl space floor. You can stand on an enclosed porch floor, an open porch floor. You can't stand above the ceiling. So we have to give meaning to those terms. I have to give meaning to that exclusion, and in this particular case, it worked with the way that we have traditionally viewed attic spaces in single-family homes and other buildings since 2013, when these definitions were introduced and this language was introduced into the bylaw.
Thank you, Commissioner. Do members of the panel have questions for Commissioner Mora? I know I asked a lot. Yeah. The chair recognizes Mrs. Sloviter.
I just have two quick questions. What is the ceiling height in the crawl space?
The ceiling height in the crawl space is less than 6'8" because if it was 6'8", it would be a basement.
But you don't know.
I
You don't
believe the
know.
plan is 6'7". I don't have the plan in front of me.
But you believe. I'm sorry. I just want to make sure I heard it correctly. You believe that it is 6'7",
That's right.
which makes it below 6'8". But since I am only 5'8.5", I could stand there comfortably in the crawl
Yes,
space. And the crawl
I
space
did.
has a concrete floor,
It
I
does.
presume. Okay. And I believe that Mr. Kuhn made a statement about the square footage. I didn't take a proper note. How much less than 1/3 is the habitable space on what you call the attic level? I think Mr. Kuhn said it's something like
0.15.
0.15 feet or
I,
something.
I believe that's right.
So 0.15 square feet, well under 1 square foot less. So if the space was 0.2 square feet larger, it would no longer be an attic. Okay.
Correct.
Okay. Thank you. Thank you, Mr. Mora.
Welcome.
Thank you, Mrs. Sloviter. Mr. Meadows, Mr. Offeld, Ms. Morton, any questions for Commissioner Mora? The chair recognizes Mr. Offeld.
Thank you. Yeah, most of my questions were answered by your questions, or the answers to your questions, Mr. Henry. I just want to explore a little bit about the change, how to characterize and how common is the change in a building permit. So in this case, we have building permit was approved, construction starts, and then there's a change which you have asked the owners to implement, and I guess has been implemented. Is that unusual? Can you talk a little bit about that, please?
Yeah, so it's amending a building permit after it's been issued. It's really common. Not necessarily for a situation like this, but it's common because we typically try to get builders and developers started with their project as soon as they can, but they might not have all of their materials, but perhaps could put in a foundation or could start work and amend it later with the information that's needed and catch up. It's pretty common in single family permitting to have changes. It started off as a kitchen design, and then the owner decided, while I'm here, it's time to do the bathroom that's connected, or add the pantry, and the scope grows. So it's pretty typical to amend a permit to increase the construction cost, to make a adjustment to the size of an addition, and update those documents accordingly.
Thank you, Mr. Offeld.
Thank you.
Mr. Meadows, Ms. Morton, any questions? I see no affirmative responses. Ms. Morton? The chair recognizes Ms. Morton.
Thank you. I guess I'm still not understanding how the habitable space on that upper level doesn't need to be counted. It really does not feel like that is actually an attic, when it is obviously habitable space. And I don't understand how that gets away with not being counted. It seems like cheating.
Yeah, when I was talking with the CRC about this, I referred to it as bonus space, because that was just how it made sense to me, is that based on the definitions that we have, the way we treat attics, and without a definition that would do something very different, which is optional. So, I've worked in other communities where the attic is defined in the zoning bylaw as an unfinished space. And if that were, our situation, then we wouldn't be having this discussion. It wouldn't be included. But I can't ignore that. I know how we've applied the terms and what we consider an attic. Our bylaw, says the top floor is an attic. And if it's not a half story, I think it's reasonable that whatever's remaining, that smaller piece that's remaining that didn't make it to the threshold of a half story, becomes the attic that it suggests there. And we end up with this as a result of the exclusion that was provided to us through the state legislation. Our old bylaw that this replaced didn't have this problem because we counted everything as habitable, that was habitable space when determining the size of the dwelling unit. And that's what we wanted to do. That's what we asked to do, and that's what we were told we couldn't do. So that
Who told us that we couldn't do that?
it was told to us through the AG's disapproval in 20 plus communities. I mean, we were one after another. We were watching all last year as the Attorney General reviewed town meeting votes that adopted bylaws that included the words habitable space in gross floor area, so that we would be talking about 900 square feet of habitable space when determining gross floor area. And that was disapproved over and over again. So we made that decision while we were in session with the CRC and the planning board to delete habitable space from our definition, because we at that point realized that we would be in conflict with what the Attorney General is doing across the state, and ultimately took that out. And we didn't make further adjustments. We didn't change the attic definition at the same time. We left the rest of the bylaw alone. And as a result, we have this ability to create additional space above the 900 square feet of gross floor area. In some cases, it's not always going to happen. There are other odd situations with this ADU regulation that some are going on in this town, some are going on in other communities that I'm seeing. It's not just having to do with attics, but it's certainly not. It's not aligned with the actual plain read and what you would think the meaning would be. Because in particular, the use of the basement provision creates a complication with how you measure the two units and end up with one larger than the other. So there are just other things, and that's probably for another day, but there's other things about this regulation that are not ideal, and not the way we would have written it.
Ms. Martin, any more questions?
It sounds like we need to change our bylaws then, if it's this unclear, because this sounds very wrong to me.
I guess I would not suggest it's unclear. Maybe, I can see that how it can be viewed as wrong. But it's not the only situation, right? So, if we have this attic space that I took you through the very simple graphic of an attic space on a 3-story building, some might say having an attic above a 3-story building is a 4-story building, right? But no, if it's an attic, you're actually not counting it as a story, because it doesn't meet that definition of story or half story. So again, that idea of a bonus space is created. So we have situations like that with ADUs and basements. You can have two equal size living spaces on an ADU on a property. If you had a vacant lot and you built two 900 square foot ADUs, and you put a basement under one, finished or unfinished, but put a basement under one and a crawl space on the other one, you have what I would say are two equal
7 o'clock.
ADUs, two equal size ADUs, but it meets the state's definition of primary dwelling and ADU. And I don't, when I look at it, that couldn't have been, I would say that wasn't the intention if I was looking at it, but it had to be pretty well known because it's pretty obvious. So, and we have an example of that in town. So when you stand at the road, it looks like you have two equal size ADUs. One's larger only because it has the basement with, as we heard, 1 inch higher ceiling height.
Thank you, Mr. Moore. Thank you, Ms. Morton. I heard it pop for a hand, but just not on the panel. Mr. Bagg, can you promote Alan St. Hilaire and or council as a panelist, please?
Yeah, sorry. Just give me one moment. I'm trying to find the attorney. Okay, coming up. So both Alan St. Hilaire and Green Miles Lipton should be able to turn on your camera or on mute. And Mr. Chair, are you authorizing them to start?
I am. Mr. St. Hilaire and council, welcome. Again, I know you've been listening for a while. You do have 15 minutes, and from that 15 minutes, if you need to offer rebuttal, you need to reserve some of that time for rebuttal.
Alan, why don't you go ahead? It's your livelihood and the hundreds of thousands of dollars you put in good faith. So, Alan, please go ahead. I'm not meaning to use my 15 minutes now. Thank you.
I'm sorry, let me clarify. You both do not have 15 minutes.
And Alan, we're having a hard time hearing you. You don't look muted, but we haven't heard your voice yet.
So if I answer your question, is the time is still running when we're not speaking? I mean, please explain, Attorney Henry.
Yes, you are the same party. So you have 15 minutes as a
In
party.
that place, I apologize for my misunderstanding, and I see you've started over. I'd like to defer so that Alan can speak as long and in as much detail as he needs, since I have put everything in writing, and I think my position was made clear in my 17-page memo. I'd like to let him speak. It's his livelihood. It's his, money he spent. Thank you.
Thank you. Mr. St. Hilaire, can you say something so we see if we can hear you? Still not hearing you.
Sometimes, Mr. St. Hilaire, if you go into the settings at the bottom, it opens up a window with audio, and sometimes that needs to be checked. One other, is the volume on your computer at the bottom lower right of your actual computer, is that all the way up? No, we still can't hear you. Sorry.
Not yet.
Mr. Chair,
Okay, now you're on as a third person, so maybe we can try this one. Unmute the new device.
Can you hear me now?
Yes, we can.
Beautiful. I'm sorry for that technical difficulty there.
Oh, that's
Uh,
okay.
Thank you, Mr. Chair and the members of the ZBA. My name is Alan St. Hilaire. I own 27 Newell Court. Thank you for giving me the opportunity to explain my position, as we have a lot at stake in this matter. I planned for this to be 3 minutes long, so I'm happy to answer questions after I've submitted my comments here. I've submitted some written comments yesterday, which didn't sound like those were read into the record at the beginning of the meeting, but Mr. Bagg did acknowledge receipt, so I would ask the board read and consider those comments if you have them. I also submitted a PDF document earlier today that shows the Newell Court neighborhood, including maps and photos illustrating how the appellant's property is located with respect to mine, as well as the rest of the neighborhood. The board may consider asking staff present those photos on screen tonight for context. Mr. Kuhn's one photo was carefully chosen so that it was actually out in the roadway on the western side of what you're seeing there and not directly between the two properties. It looks like Jeff's got them up there. So you can see on that graphic, Newell Court, that yellow outline shows my property as well as the private way. In the lower right portion of it shows the ADU, and the upper left portion shows Mr. Kuhn's property. If you could advance to the next slide, there is the just the map rather than the aerial image of the same map. Next slide. This first image shows walking down Newell Court looking to the south with Taylor Street behind you, 9 Newell Court on the right, and number 10 Newell Court on the left. And off in the distance on the left, number 12 Newell Court. If we go to the next slide, that shows progressing further south on Newell Court. I'm standing at the end of Mr. Kuhn's driveway. In the lower right corner of the screen, you see the arrow showing where 9 Newell Court is. The shrubbery there is actually at the edge of his driveway. And in the upper left third of the image, you can see the very peak of the ADU, perhaps only 1.5 or 2 feet of the peak of the ADU. The large majority of it is obscured by the shrubbery. If we go to the next slide, you will see the principal dwelling, 27 Newell, the red hip roof structure. Ahead of you, as we get closer to my property, you can see that the ADU disappears from view of the abutter. You can see 9 Newell Court, lower right corner in the direction of their home. 12 Newell Court across the street to the left. If we go to the next slide, now you can start to see the ADU come into view. This is standing in the circle as shown on the map of the neighborhood. And 9 Newell Court is over the viewer's left shoulder to the northwest. If we progress to the next slide down, this is the view that Mr. Kuhn had taken, which you had to have been standing in the roadway to see it, because you can see all the shrubbery that obscures his view of the principal dwelling at 27 Newell Court on the right and the ADU across the circle. If we go to the next slide, you'll see the, this is now with my back to the ADU, looking at Mr. Kuhn's property across and up the street. You can just start to see his dwelling just eking out beyond the shrubbery and the trees. In this lower left corner, you can see 27 Newell over your left shoulder, the principal dwelling. If we go to the next slide, you will see this is standing on the front doorstep of the ADU looking towards Mr. Kuhn's property. It becomes pretty clear that there's no direct line of sight between the properties. If we go to the next slide, This is a view standing in the parking area looking north, and you would see Newell Court if in the center of the frame if it wasn't obstructed by the shrubs. And this shows the relationship between the ADU and the appellant's property. I believe this is the last slide. So that I just wanted to use to establish context in the neighborhood and that there's not really any direct line of sight from the Kuhn household and nothing of any substance from the Kuhn property at all. Beyond that, before I go forward in my comments, are there any questions about what I've just shown? Okay. So I'll continue. In late 2025, we worked with the Amherst Building Department to submit a building permit application for a protected use ADU at Newell Court. The building department reviewed the application, the plans and supporting documents, and determined that it met building code zoning requirements and issued the permit. Upon issuance of the permit, we commenced construction and have continued to rely in good faith on the unchallenged building permit for over 5 months, investing hundreds of thousands of dollars. Commissioner Mora, I think, did a fantastic job of explaining the gross floor area, so I will not go into that further. Our gross floor area calculation was confirmed by the building department when we submitted our building permit application, and of course was corrected slightly when Mr. Mora pointed out the difference between building code and zoning measurement for the attic space. I do go into more detail in the written submissions that I sent in yesterday. I would like to point out as a second point, the appellant's claim to injury over added occupancy or density due to added living space is incorrect. Between Mass Fire Law and State Sanitary Code, I can legally house 5 occupants in a dwelling containing 900 gross floor area, whether it was on a single story with all gross floor area between the exterior walls, or whether it included attic space. The upper limit of 5 occupants is what prevails here, so I could have 5 occupants in either configuration with or without a habitable attic. So there is no increase in density or occupancy that could take place under the relevant building codes, which is by definition how the state ADU law spells out what you can and cannot do on these ADUs. I am requesting that the board uphold the determinations of the building commissioner in this appeal, as I will suffer significant financial injury otherwise, as we've relied on the unchallenged building permit since the issuance back in November. I thank you, Mr. Chair, and the members of the board for listening to and giving me this opportunity. I'd be happy to answer any questions that the board may have based on my presentation.
Thank you, Mr. St. Hilaire. Attorney Lipton, would you like to add anything before I stop the timer?
I'm sorry, sir. Green Miles Lipton is the name of the law firm of which I'm a partner. I just want to be clear on the record. My name is Michael Pill. P as in Peter, ILL. I am a real pill. I can't deny that. I would like, please, the opportunity to wait and see what other people have comments and then see if we have anything to say to use up our remaining time. Thank you, Mr. Chair.
Thank you, Attorney Pell. Mr. St. Hilaire, why should the exclusion for attics in the gross floor area definition listed alongside crawl spaces, garage parking areas, and enclosed porches extend to finished heated bedroom space with a stairway and code compliant ceiling height rather than being limited to true unfinished attic space consistent with the NEOL on P3?
So the gross floor area calculation is including all stories of compliant ceiling height. The attic doesn't fall under the definition of a story, as Mr. Mora explained earlier. And also the attic exclusion in the state protected ADU bylaw, as well as the Amherst bylaw, is very specific that the attic space is excluded. It doesn't say unfinished attic only. It doesn't say finished attic only. So our design, as Mr. Mora mentioned, as bonus space, our design is compliant with the definition of gross floor area And the definition is very important in zoning, in building code and health code and many other laws. So we followed the definition that was available to us. And as Mr. Mora mentioned, it is sometimes counterintuitive, but that is the law. We followed the law in good faith. And so I think Mr. Mora did a great job explaining how you can have a habitable attic that does add additional living space. Living space and gross habitable area are two different definitions. So I do want to be clear on that.
But doesn't P3 label an 8-foot ceiling height, and P4 shows an 8.1 upper level section, which are both above the building code's habitable threshold? So why should space at that height containing 2 labeled bedrooms and a bathroom be treated as an attic rather than count towards the GFA?
Because as Mr. Mora explained earlier, a habitable attic can, under the zoning bylaw and under the building code, include finished space. So there's no dispute that there's finished space there, but under the definition of gross floor area, with the attic being excluded, it doesn't add to the 892 square feet on the first floor. I think that Mr. Kuhn's interpretation of the definition of an attic is just a framed space with some cobwebs and boxes of old papers, when Mr. Mora's definition of the attic, whether it be finished or unfinished, remains excluded from the gross floor area calculation.
So is it your position here then that the primary issue is this board making a formal interpretation of what is attic versus not attic?
I think that the appellant's position is the interpretation of the definition of gross floor area, but that's been established at both the state and the local level, as Mr. Mora explained earlier. So I am not an authority to say whether or not, that's to be included in the gross floor area. I don't know if this is the right forum to interpret state protected use ADU definitions. The state protected use ADUs are protected by the Dover Amendment, which is allowed to things like places of worship and education, one of the highest protections in the state.
You argue that if we were to rule against you on this, you'll be out hundreds of thousands of dollars. But isn't it fair to say that the moment Mr. Kuhn filed this appeal, you were put on notice that this could be reversed? What steps did you take once you know there was an appeal to protect your interest? Did you stop work? What did you do?
So once we got the notice through Mr. Mora that appeal was being filed, we didn't stop work completely. We did slow down. We did think about, what the possible outcomes would be. And so we haven't had significant construction since. We've had some work with plumbers and electricians to start to do the rough work. Mr. Mora was clear earlier that he didn't put a stop work or a cease and desist. He never once told us that, the building permit was suspended or, we should stop working. So we continued to work, under a valid building permit. And that's where we are today.
Thank you, Mr. St. Hilaire. Are there any members of the panel who have questions for Attorney Pill or Mr. St. Hilaire? And the chair recognizes Ms. Morton and then Mrs. Sloviter.
So, I would say that even if we were to say that the upper floor had to be counted as part of the square footage, that wouldn't mean that you had to tear the building down. You would just need to not build out that upper floor, and that upper floor would need to be made so that it could not be habitable space. So a true attic. So you wouldn't really be out a lot of money. You just wouldn't be able to build out that upper floor.
So I want to be careful about what you're saying is a true attic. I think Mr. Mora did a great job of defining attic space under the zoning bylaw, and that it can include habitable space, and that it is a bit counterintuitive to what common knowledge might apply to an attic. It would be a significant expense to tear out the rooms that have been framed and wired and plumbed in the upper story, and it would have a significant impact on the future use of the property because we'd be confined to the first floor level only. And if we had been told that that would be the determination through zoning and building code at the time of applying for the permit, we would have designed the dwelling differently. To have only 2 bedrooms and 1 bathroom is a very, very significant handicap on the property. And it doesn't help to provide much needed housing in Amherst. So that is the big impact if, there's some ruling here that overturns the commissioner's findings.
Thank you.
Thank you, Ms. Morton. Mr. Sloviter?
Is there in the design, I don't have it in front of me, I'm sorry. Is there in the design access from the first floor to the crawl space?
Yes, there is.
And is that a staircase?
It is a staircase, yep.
Okay, thank you. One other question. You made an assertion that Mr. Kuhn does not have visual access to the ADU because of the large, I don't know, bushes, shrubbery, leafy growth, whatever. I forget the term you used. I was told when I applied to the town for permission to modify a built-in porch that shrubbery or any plant growth is not taken into consideration when assessing a project because it's not permanent. Are you aware of that?
So to understand your question, you made an example of your porch project. What was the determination in regards to a permanent visual block?
The porch project was supposed to be not visible, and all of the plant growth, the tall hemlock trees around this porch, which made the porch not visible from the street. I was told at that time by the town that that is not a consideration of whether or not the house is visible from the street. So I'm trying to clarify what the town, if what you're aware of in terms of existing shrubbery or foliage of any sort. How is that relevant to Mr. Kuhn not being able to see the ADU? Because I was told that if that stuff dies, then things change. So
Sure.
I'm wondering about what you're asserting.
Sure. Well, I think that Mr. Pill can speak to the legal technicalities, but what I'm asserting is that to claim injury that is special and different from everybody else in the neighborhood, the appellant would have to say something, along the lines of, "Oh, he's built a 3rd-story deck and he can view right into my bedroom window," and that doesn't apply to any of my neighbors. So the point of the shrubbery and also the distance, there's over 150 feet between our properties, and we don't actually share any property lines. Kuhn is across the street and across the circle from my property. So it's not like our 2 houses are 30 feet apart and we can wave to each other through the window. So that was the reference of that. As to the efficacy of vegetation versus fences or walls, in previous special permit applications, we've been afforded for screening of parking areas and such, either fences or vegetation. So I believe that vegetation is considered a viable screening between neighbors. That's something that if the building commissioner could add to if need be, but that's my understanding.
Okay, thank you very much for that.
You're welcome.
Thank you, Mr. Sloviter. The chair recognizes Mr. Offeld.
I just am curious if you can enlighten us a little bit on how it came to be that the upper level needed to be redesigned. That is, the original design was larger with the closets up there and so on. And then that had to be amended as the building commissioners described. So could you tell us your part of that story?
Sure, I'd be happy to. So when we first designed the ADU floor plans, as Mr. Mora mentioned, the designer did the calculations, and Mr. Kuhn pointed out that just the building space, just the living space for the two sleeping rooms, the bedrooms, were counted. Because if you look at the building code definition, it excludes closets, hallways, bathrooms as habitable space. And we were told that we could have habitable space in the attic as long as it was under 1/3 of the area below. And with the input of the building code excluding everything but the bedrooms, that is where the discrepancy rose. When this appeal came to be, Mr. Mora approached us and explained that difference. And then we quickly complied with that. With his explanation, it made more sense. So there was a bit of a difference of measurements that was clarified for us.
Thank you.
You're welcome.
Thank you, Mr. Offeld. Mr. Meadows, any questions?
No.
Thank you, Mr. Meadows. Mr. Kuhn, I will give you an opportunity to add anything you want since you have some time left before I go to public comments. After the public comments, there is an opportunity to add anything. So if you want to rebut anything that Mr. St. Hilaire said or Commissioner Moore says, this is your opportunity, and you have about 9 minutes and 21 seconds.
Thank you. No, I'll keep it brief. I just need to correct two factual statements. First, and I'll try to share this again. First, our parcels do directly abut. You can see the two properties here. I don't know exactly the number, but I think it adds up to about 190 feet of, continuous linear connection. Mr. St. Hilaire's property is in the yellow and mine is in the blue, so you can see the line being shared. Second, the ADU is visible from portions of my property, and the visibility increases when the deciduous foliage is gone. So, the owner's own photographs show the ADU from areas near my property line. But at the end of the day, standing does not depend on an unobstructed view from every point in my yard. So I directly abut the property. We share private access serving it. And so I just wanted to correct those two things.
Thank you, Mr. Kuhn. We are at 7:28. I did commit to rebuttal time, Mr. St. Hilaire. For full disclosure, you have about 7 minutes and 15 seconds. I know you just spoke, but would you like to add anything else?
Thank you, Mr. Chair. I would like to clarify. It seems that Mr. Kuhn is counting the entirety of Newell Court as my property when he states that the property lines abut with 190 feet of frontage. And perhaps Mr. Bagg can bring up the graphic on the second page of my presentation, but I do not own the entire public way. That is how the tax assessor has shown it on their maps. But a previous attorney has explained to me that each of the abutters own to the center line of a private way. So if we can go to slide 2 and kind of zoom in a bit on Newell Court, the private way. On the westerly side of Newell Court, I believe that Mr. Kuhn is stating that entire line highlighted in yellow is a joint property line of ours. However, Newell Court bisects our two properties. So if there's any kind of connecting tissue at all, it would be between 9 Newell Court and 35 Newell. But I don't see that. There's a property line that goes between 3527 and approaches 9. So I just wanted to clarify that. Um, and I'll leave it at that. If Mr. Pill wants to add anything, I'd like to afford him some time to do that.
Mr. Kuhn is incorrect. The tax assessor is also incorrect. Mass General Laws, Chapter 183, Section 58, called among us dirt lawyers the derelict fee statute, makes it clear that everyone's property line goes to the center of Newell Court, subject to easements. And I have tonight just looked at the deeds. Everyone has a right to pass and repass. And I respectfully disagree with Mr. Meadows. The fact that a child speculatively might be allowed to be in the street, that does not create standing. Mass General Laws, Chapter 48, Section 17 says measurable injury to a legally protected interest different from harm to the community generally. And according to everything that everyone has put up here, Mr. Kuhn has a house beside his, 2 houses across the street, looking at someone else's house in densely packed Newell Court does not give standing. That's not measurable injury to a legally protected interest protected by the Amherst zoning bylaw, different from harm to the community generally. And under the deeds, if one goes through the title history, and I'd be happy to submit that if the board wants, everyone has an equal right to access up and down Newell Court. And in other words, there's been no basis for standing. Furthermore, has Ms. Morton left the hearing? Because I specifically wanted to address her concerns. Oh, there you are. Great. Thank you so much. 2 things. One, I think Ms. Morton made a very insightful comment about the need to amend the zoning bylaw. Mr. Mora also stated that when he was interviewed by Amherst Indy. If there is an issue here, that's what needs to be done. Go to the town council, Mass General Laws, Chapter 48, Section 5. The bylaw provides it. It's cited at the end of my memorandum. That is the way to deal with this. And with respect to the issue about what Mr. St. Hilaire did, what is absolutely crucial to keep in mind is we're talking hundreds of thousands of dollars from January to May, when his building permit was completely unchallenged due, sadly, to Mr. Kuhn's failure to inspect the plans, which, as you've seen, the habitable area in the attic in December was even larger than the habitable area today. And I respectfully submit the legal authority I cite makes it clear that it was Mr. Kuhn's obligation to inform himself as to the law and to review all of the plans, not blame Rob Mora because he asked for something and didn't get what would have showed what he waited 5 months to challenge. Alan St. Hilaire spent hundreds of thousands of dollars from January to May, while Mr. Kuhn allowed the statute of limitations 30 days from the issuance of the permit when he knew about the permit. And the case law I cited makes it clear that's the operative point in time. The statute of limitations expired. And now Mr. Kuhn is asking you, in effect, to destroy his investment. Of course, he can rebuild the property. He shouldn't have to do that when he proceeded in good faith for 5 months and spent hundreds of thousands of dollars. This belongs in the hands of the town council. And the only other thing I want to note is I would hope that, and I note that Mr. Kuhn, and believe it or not, he and I agree with something. With his supplemental submission, he asked you, I believe, to make findings both on the statute of limitations issue and on the standing issue. And I respectfully submit you have an obligation to do that. I do certainly hope, you are free to make what would amount to dicta comments about the merits of the case, but it would be grossly unfair as well as not correct legally to pull the rug out from under Alan St. Hilaire. Please take this to the town council and clarify the zoning bylaw. I certainly don't dispute it could use some clarification. The final point is with respect, and again, I'm glad Ms. Morton is here, a true addict, Ms. Morton, and I just did a little online research, but I'm familiar with this. I have a master's degree in planning. I'm not a practitioner like Mr. Bagg, but I do have a master's in urban planning. The mansard roof, Mansard. There's a number of them in Amherst, in 19th century houses. It dates back to 16th and 17th century France. Francois Mansart, Mansart, was the architect. In other words, an attic as living space has been part of building design and construction since the 16th and 17th century. And those are as much true attics as the attic here. And I respectfully submit that supports Mr. Mora's interpretation. I thank you very much for your time, and I'll be quiet now. 3 seconds to go. Thank you.
Thank you, everyone, for your presentation as well as your answers. At this time, I will take comments from the public. Members of the public who wishes to make a public comment on this appeal may do so by raising their hand or pressing the #9 option on their telephone. Please be mindful that public comments are limited to 3 minutes. And given that there are a number of people in the audience, we will strict very close to that 3 minutes. We will strictly adhere, rather, to that 3 minutes.
Okay, and so in the audience, I see I'm gonna promote Molly Strayhorn to panelist so she can unmute, and then I see Ira Brick. Those are the first two people that have raised their hands. So just give me a moment to do that. Okay, Miss Strayhorn, you should be able to turn on your, and I see some other hands going up, but you should be able to turn on your camera and unmute if you wish.
Again, as a reminder for everyone, before you speak, please just state your name and address for the record, please.
Thank you, Mr. Chair and members of the committee. My name is Molly Ryan Strayhorn, and I am in a abutter. My address is 35 Newell Court. I directly abut 27 Newell Court, and you can see me on that map. I was also referenced in Mr. Kuhn's original filing because there was an email exchange that I saw in December to get a copy of the plans. When I got the copy of the plans in December, what I saw was an ADU that was less than 900 square feet. 3 Mattoon, which is actually the house right across from me, is 909 square feet. So in my mind, I thought I understood what that would look like in our neighborhood. As has been mentioned, we are a very densely populated neighborhood. We are on a private road, and to address the particularized harm, we do pay for both the upkeep and the plowing of this driveway. So an additional neighbor definitely has an impact on the livelihood of the neighborhood and all the money that we put into maintaining the road. I'd also like to say that the infrastructure that we have also would be impacted, including the trash, water, sewer, privacy, and noise, because noise can travel through any kind of bushes, any kind of foliage, whether it's winter or spring, that definitely impacts us. The other thing that I would like to say about our particularized harm is that we do a good job as a neighborhood, making sure that everyone feels welcome and livable in our neighborhood. We train undergrads when they're driving down the road, and we make sure that noise is respectful to everyone. So to address one thing that Mr. Hilaire said is that 5 people could live there, whether it's 900 square feet or the proposed 1,200 square feet. So if they're confined to the first floor, then I question what the particularized harm for him would be if he just had to have people living on the first floor, if he can have the same number of occupants, whether it's 900 or 1,200 square feet. Let me look at my notes to see if I have anything else I'd like to bring up. I think I would like to just add, I appreciate everything that Noah Kuhn has brought forward so you can address this. It's going to be something that comes up a lot in Amherst. I'd also like to submit written findings after this to talk about the impact that this has on my family. I see my time is quickly eroding and there's other people who want to speak. Thank you for the time, Mr. Chair.
Thank you.
So I'm promoting Ira Brick as a panelist, and I'm going to move Miss Strayhorn back as an attendee.
I am Ira Brick from District 4. The spirit of Amherst ADU rules and the state law behind them was to add modest housing options, not to open the door to what is effectively a second large house with 4 bedrooms. That's the concern many residents are raising now. The law was sold as a way to create small secondary living space, but the way it's being used today may be stretching that intent beyond recognition. It's also hard to ignore how little interest there seemed to be in ADUs in Amherst before this recent loophole or confusion, and then suddenly there are 9 permit applications, according to the building supervisor. I've also heard there are over 40. I just put in a request for that today. That suggests the rules may be creating an incentive for a kind of development that was never the real goal. Amherst should not be afraid to say clearly that it needs rules that fit Amherst, not just generic state language copied onto every town. One of the biggest problems is the use of gross floor area instead of actual living space. That is absurd if the goal is to regulate the size of a real home people live in, not every inch of unfinished or incidental area on a plan. The town should be measuring what actually matters, the habitable space that creates a real residential unit. I think Amherst should pause and put a moratorium on ADUs until this is sorted out clearly and openly with the state. I also think the town should have a legal fund so we don't just forfeit ourselves because we avoid being confronted or sued when we do what is good for our town. This is not anti-housing, it's responsible governance. Other communities, Nantucket and Martha's Vineyard, to name 2 brave towns, have been willing to stand up for their local needs, and Amherst should be just as brave in protecting what makes sense here, given our circumstances are different from many other towns in Massachusetts. I also want to say that possibly the delay in Mr. Kuhn complaining is that Amherst now doesn't notify neighbors of an accessory dwelling unit is being built nearby, and they're built by right and only require a building permit. And the other thing about fitting 5 people in an ADU, I just quickly asked AI how many people fit in a 900 square foot ADU, and it'd be like they are typically 1 or 2 bedrooms with the living, dining, and kitchen area in an open concept being 350 to 400 feet, bedrooms 250 to 350 feet, bathrooms 50 to 80 feet, hallway, closets, and utilities 50 to 100 square feet. So that 900 square feet gets eaten up quickly before you can squeeze 5 students or people in there. Thank you so much.
Thank you, Mr. Brick.
So now I'm promoting Aaron Goldman, and should be able to unmute yourself and turn on your camera if you wish. And I'm gonna move Mr. Brick back into as an attendee.
Hi, everybody. Thanks for letting me chime in here. I'm in a butter. Maybe you could bring up the plot map so you can see my property. It wasn't labeled for some reason on the map that was up, but I can point it out. I'm a butter to this property. I'm also in a butter to one of Alan's other properties on the other side of my property. And I also have 2 kids, and everybody keeps using the word like maybe it's counterintuitive. I don't think it's definitely counterintuitive, but I think what people really mean is it's contrary to the purposes and objectives of this board, of the town, of the values, of the intent of the legislation. So at a very minimum, even if you feel forced to approve this, it seems like it would be very appropriate for this body in the town of Amherst and even the planner to say this is completely contrary to our objectives and values without prohibiting what he's doing, perhaps. So that seems to be what the subtext of what several people have said already. in terms of the measurable injury, it's definitely safety, it's definitely visual. The point about these projects just spontaneously appearing is disturbing. That's not neighborly at all, right? That's designed to get away with stuff, right? Loopholes, the word has been used, bonus, and um, uh, oh, um, Mr. Pill keeps talking about how he spent hundreds of thousands of dollars. He said that like half a dozen times. If someone is spending hundreds of thousands of dollars in ways that are contrary to the objectives of this board and the town and our values, that's not something we automatically try to support and sustain, right? That becomes an expression of the threat, Mr. Pill, not a reason why we should support his work. Um, and the other thing that we all know, but no one's saying, is this is for student housing, right? And I'm all for densification, but that has a tangible, measurable impact on the quality of life and property values, right? We all know that we're trying to make sure that we have real neighborhoods with families, and sure, sprinkle some students in here, but one by one, the town is being converted to dormitories. And Alan has done a good job of making sure that the tenants are relatively quiet. But when they have guests, they're loud, and every weekend there are beer cans thrown over the fence, right? So that's just a fact of life of having UMass students around, and it needs to be done in a moderate, sensible way. And we can tell with the basement and with the attic that every measure is done to artificially create more space.
Thank you, Mr. Goldman.
Thank you.
Thank you. So now I'm promoting Yupan Zhang, and then the person after that who has their hand raised is listed as James McAllister, and then after that there are currently no other hands. Trying to again for Mr. Zhang should be coming. I'll give that one more try. So it doesn't seem to be working for Mr. Zhang. I'm going to try another option, which is to allow to talk. So this should allow Mr. Zhang to unmute and at least speak, if hopefully that will work. Mr. Zhang, you should be able to speak, and you've been promoted to, oh, it looks like you declined to be promoted, but you should be able to unmute and talk.
Maybe we try that.
Hello, can you hear me?
Now we can.
Okay, thank you very much. Good night. I just have one thing to point out. So if the ZBA member decided to say building commissioner made a mistake interpreting the bylaws and the state law and ADU and stuff, we are just joining the 20-some town already say that to the state. And then so it will be 20-some plus one saying the same thing. And this is like, let's say, fool's errand, right? This is not the right forum, and this is not the right channel to do that. Again, it has been pointed out more than once, there is the right way to do it. And even if we reduce the square footage to, I would say, 2 bedrooms, 3 bedrooms, the demand is there, okay? There will be supply to meet the demand. What we are talking about doesn't really change anything. That's my honest opinion, and that's that. Thank you very much.
Thank you, Mrs. Zhang.
Great. And then the person listed as James McAllister didn't unraise their hand, and I'm gonna try promoting what's labeled as iPad MO with a bunch of numbers. So that person should be able to turn on your camera and unmute if you wish.
We cannot hear you, ma'am.
Mr. Chair, obviously the person's having a little technical difficulty. I could move on to the next participant and keep this person on panelist in case they can find
Thank
the
you.
sound.
Thank you.
So I'll be promoting a person named Magnus Wennemir. So just bear with me for a moment here and promote to panelist. So Magnus should be able to unmute and turn on your camera if you wish.
All right. Can you hear me?
Yes, we can.
All right. On the first try. Yes, I'm Magnus Wennemir. I live on Gray Street. There are 3 of these coming up within 100 yard of us. We own 65 Taylor Street also, and one is the direct neighbor to us. I don't want to belabor what's already been stated, but I wanted to emphasize this point that we were never given any notification and there was never any invites to any ZBA meetings regarding any of these properties near us, which may be the appropriate process, but I would submit that it would be better if public comments were invited when, really there's a big building coming up right next to neighboring yours. And in this case, there wasn't for either of these. And I don't know if that was just the mailman or what, but I would humbly submit that that would probably be a preferred process. Thank you.
Thank you, Mr. Meyer.
Okay, and then the last the person named Jay McAllister did re-raise their hand. I'm going to promote them to panelists, and maybe we can give that other attendee one more try. So, James McAllister, you should be able to unmute yourself and turn on your camera if you wish.
Okay, can you hear me now?
Yes, we can. Thank you.
Okay, good. So I live right next door to the ADU that we're talking about. And speaking about having no information about this, when I walk out my side door, it's right there in front of me. I had asked Mr. Sain, I saw him measuring in his yard quite a few months ago, and I asked him what he was measuring, what was going on. He said he's measuring for a garage for the girls who live in the house. So that's the information that I got. Not only did I get no information, I got misinformation. Then all of a sudden, several months later, there's trees are coming down, and there's the basement is being built and the foundation. And I asked him who is going to live there. He said a family is going to live there, not a whole bunch of students. And I mentioned to him that now I no longer can see the mountains. I had a view of the mountains. He said, "Yeah, but you only saw them in the wintertime when there weren't any leaves." And then the most horrible part about it is that he built it so that the bedroom upstairs looks directly into my upstairs bedroom and my downstairs my bedroom. And my bedroom has a deck and it has sliding doors. So one wall is all glass. And I no longer have any privacy at all. And whomever stays upstairs in the bedroom has no privacy. And he built it exactly so it views right into my room. He didn't put it back a little. He put it right there, smack dab, right in front of me, directly with a view into my bedroom. And I'm just, it makes me want to leave Amherst. We've been there over 15 years. Well, my husband has passed away now, but we've lived in that house, and it just makes me want to leave Amherst. Everywhere when I walk around the neighborhood, everywhere I look down the street, there's another one of these popping up. I feel like I'm living in the city. I think that this is just ruining Amherst, the quality of life in Amherst. And it certainly has ruined my quality of life. That's, I have to now find a way to block that view right into my house. It also views into my kitchen and views into my dining room. That's not as much of a privacy issue as it is in my bed.
Thank you, ma'am, for your comment.
May I ask, maybe I missed it. Did you get the name and address for the record? I may have missed it.
My house?
Just your name and address, yes.
12 Newell Court, and it's Eunice, EUNICE, McAllister, MACALLISTER. James was my husband. He passed away in March.
Okay. Thank you.
Thank you, Mrs. McAllister.
Okay.
Mr. Bagg, is all for public
Yeah,
comments?
there are no other hands raised in the participants list.
Thank you very much. It is 8 o'clock, and we do have another applicant that was continued from July 9th on tonight. There is a lot of information that was presented. I know we've spent time going through most as possible, that some of us may need more time. I know that I do need some more time. I took detailed notes here as well as before I was reading. So at this juncture, I would suggest we continue this to a date certain, give us time to think this over, and then come back on that date and deliberate on this appeal. If members of the board think that they are in a position tonight, I see no heads in the affirmative. So I think we're all in agreement to I see Mr. Slover's hand.
No.
Yeah.
No.
Mr. Slover, you're on mute.
Yes, I was. We've heard a lot of information, but I don't know that that precludes us from making a decision tonight. I believe we need to go to a public meeting after this in order to share our views and then vote. But I don't know that that would automatically preclude us making a decision tonight. I'd be willing to do it. I might suggest that it's 8 o'clock and my back would like a 3 to 5 minute break since we're a half hour after our normal break time. But I'm willing to go forward tonight. I don't think it's going to take that long.
So
I agree with Mr. Sloviter. I don't believe we want to push this off to a date certain. We want to do it tonight. We've had plenty of information. Sleeping on it is not going to do us any good, nor forgetting some of the things that were said tonight. I think we have had many meetings that have gone to 9:30, 10 o'clock before. We can continue on and as long as we need to. Thank you.
As a matter of procedure, let's go in the public meeting to have that conversation. And then in fairness to Mrs. Sloviter, we vote for the public meeting, and we'll take a quick recess and then come
It's
back.
8 o'clock.
Yeah. So I would entertain a motion to move to a public meeting to deliberate on the appeal while keeping the public hearing open. Is there such a motion?
So moved.
It has been
Second.
moved. Is there a second?
Second.
It has been moved in second. Any discussion? With no discussion, the vote occurs. Mr. Sloviter,
Aye.
Mr. Offeld,
Aye.
Mr. Meadows,
Aye.
Ms. Morton,
Sorry about that. Aye.
thank you. And the chair votes aye. The vote is 5-0. We will now move into a public meeting while keeping the public hearing open. And given that we've been here to Mr. Sloviter's point for the last 2 hours, as a matter of order, let's take a 5-minute recess.
Thank you.
Thank you.
I can hear you. So they need 4 votes to overturn Mora. It's called a supermajority. How do you read those 5 people? Who's Eunice McAllister? What's the story there?
Attorney Pill, you're on mute. I am sitting here, but just so you know,
Oh my God, I'm so sorry.
That's okay. think the full panel is back. I'm not sure if Mr. Meadows, you're there. I see that you are unmuted.
I'm here, but I'm eating something and I don't want to make anybody hungry.
That's okay. I understand. So we are in the public meeting. So this is not an opportunity for the applicant or the appellant to add information. This is a chance for the board to deliberate on the appeal as well as get a temperature of where people are in terms of the position. So I will go around my screen to get people's input, and I will go by order of my screen, and I will start with Mr. Offeld.
Mr. Chair, just to clarify, you had commented on postponing until a date certain. Is that something we're not going to do? Is that what we're discussing, or are we discussing the actual case before us?
So I will leave it as if you are comfortable making a decision tonight. So I think there are two options, making a decision tonight or continuing to a date certain. And I will leave it to each person to make that determination based on what you heard, what you've read, and how much time you need. And then we'll put it to a vote.
Okay. Are you interested in where people are leaning or inclined or on the case itself?
Yes.
Okay, very good. Well, we have this is the beginning of my second year on the board, and I believe this is the first appeal we've had of this sort. And I think it's probably the largest volume of material coming in on a case before us. And I haven't digested it all. We got something even this late afternoon or evening. So that's just a fact. I've read much of it, but so I could make use of, I could review more material. I think I'm getting the picture though, and I have a preliminary inclination. From what I've seen so far, and again, it's incomplete, but from what I've seen so far, I'm concerned about standing of the applicant. It's not clear to me. We are charged with reviewing orders and decisions of the building commissioner. We can receive appeals of those. So was the May email correspondence that's been described, does that constitute a decision? I'm not so sure. That's a question for me. Was the decision point the issuance of the building permit? I think that's more likely. The harm claimed, that whole issue is something I might want to look further into. What we've heard from many commentators, both those who gave public comment this evening, and thanks to all of them for speaking, and also some letters we received, was a very clear concerns about these ADUs being built with no notification to the public, or neighbors rather. ADUs being put in the neighborhoods, and concerns about noise and student parties and traffic and so on. These are all legitimate concerns, but it's state law, and we have no control over that. We also heard that the definition of the attic is strange, unusual, perhaps. That does not make sense. We've heard several of our
Killian?
Hello? Okay.
Someone accidentally unmuted. I just muted them.
Okay. We've heard even I think I'm correctly characterizing Commissioner Mora's statements that the staff isn't terribly happy with that definition, but that's the definition we have. And I'm not clear that it's the role of this board to change the zoning bylaw. I think that's up to the town council. And we just have to enforce the zoning bylaw as it exists. So, I think that, and not, I'll stop there. I could probably say more, but that gives you a rough idea of where I'm at.
Thank you, Mr. Offeld. Going back to Mr. Meadows, I think I skipped you.
I don't know if you skipped me, but I'm.
No.
I didn't know. We've never had a line, so
No.
there's nothing to skip. I find the tortured explanation of how definitions for attic came about to be somewhat similar to our current administration's definition of what's going on in Iran. No, it's not a war. It's a conflict. Well, it's not an addict. It is an addict. And it is this board's obligation to make a decision here that should impact ADUs going up from now on. If it were not our obligation to make a decision, then we wouldn't be in line to do so. I find it impossible to go beyond the 900 square feet that is called for an ADU. In my estimation, any additional square footage makes it not an ADU. Be interested to see what the other board members feel, but I think you understand where I'm coming down on this.
Thank you, Mr. Meadows. Mr. Sloviter?
The definition of an attic is an unfinished space or room located directly below the pitched roof of a building, most often utilized for storage. The definition of attic includes function. An attic is normally used to store things, suitcases when you are not traveling, Christmas decorations for 11 months of the year, boxes of personal items that people are too sentimentally attached to dispose of. In almost every case, a real attic is not finished and normally does not have easy access in the form of a permanent staircase. It also does not include a bathroom. A building of this size would normally have a pull-down stair access rather than use precious living space for stairs that is seldom used. You can call something anything you want, but that doesn't make it true. I can call my Honda a Ferrari, but it's still a Honda. The rule of whether this is an attic or not, in this specific case, turns on 21.6 square inches, which is half the size of a standard number 10 envelope. No one disputes the by right ADU under 900 square feet. But the ruling that the attic, that the living space on the second level in this case is an attic and not residential living space, or however it would be called, makes a mockery of the ADU 900 square foot rule. Not counting the second level seems a clear attempt to circumvent the rule and its intent. It is disingenuous to deny this clear attempt at increasing the number of occupants beyond the 2 on the first floor in compliance with the intent of the ADU rule. Even the crawl space, which is also excluded, would easily accommodate another occupant as long as he was not a member of the UMass basketball team. It is almost certain that it will be students as occupants. The history of rentals in Amherst indicates 2 things. 4 bedrooms means 4 students and 4 cars. Non-owner occupied means more likelihood of a nuisance, which we are charged with preventing. I respectfully disagree with Mr. Offeld that we are forced to enforce the rule if it conflicts with our sense of what is right. I agree with Mr. Meadows that we are here to make a decision. Common sense has a role here. It may come down to a question of definition, but our responsibility is to use our brains and our common sense and our sense of civic duty to protect the residents of Amherst. I understand that there are definitions on all of that, but I cannot support this project as it stands, calling 2 bedrooms and a bathroom and walk-in closets as not being a space that is counted in the square footage of living space. So well, that's what I feel, and I think that we are charged with using our heads. Thank you, Mr. Chair.
Thank you, Mrs. Silver. Ms. Morton?
I have to say that I agree with David and Craig that the intent of the ruling, the law, is that it's supposed to be a small unit, and including that space on the upper floor is cheating. So that's the way I'm leaning.
Thank you, Ms. Morton. For me, the core question comes down to both the GFA definition under the CMR 760, CMR 71.02, and bylaw 5.0112 count the sum of areas of all stories of the building of compliant ceiling height while excluding crawl spaces, garage parking areas, attics, enclosed porches, and similar spaces. For me, the question is whether the finished second floor space shown on sheet P3, 2 bedrooms, a bathroom, closet, stairs, and landing, under a stated 8 feet to 8.1 ceiling height falls within the attic's exclusion. I think it does. We might not like the idea that it is being used as an ADU because of the square footage that is required, but by the definition itself that Mr. Moore presented, that the bylaw excludes attic from the gross GFA, an attic is an attic. One of the reasons that the exclusion has no qualifier that it has to be habitable, and that omission has to be meaningful. So even though that, even though it is being built out, nothing in the bylaw or the statute that allowed automatic ADUs by right limits the word attic. Both simply exclude attics, full stop, in the same clause as crawl space, garage parking areas, and enclosed porches. So where state regulation uses unqualified language that a comparable local bylaw elsewhere uses in qualified form, the absence of a qualifier, I would argue, is evidence that no such limitation was intended. So I support Commissioner Moore's position that it is an attic under the definition of the bylaws. I appreciate what the abutters are saying about, the ADU space, and that is a separate issue. The ADU, there is no argument that the state law, the bylaw, requires that ADU be a certain square footage, otherwise it is not. But that is not the core argument, I think that's before us. The question is, an attic, by definition, in the bylaw, in the statute, is excluded from the GFA. And I think by the reading the interpretation, listen to Mr. Moore, looking at the statute, I would argue that it should be excluded. On a practical perspective, there is very little modern buildings today, construction, wholly unfinished, storage-only attic space of the kind that Mr. Kuhn's reading would require to trigger the exclusion at all. So if attic means only bare, uninhabited roof cavity space, the exclusion would rarely apply to any modern ADU built with a habitable upper level, rendering the word close to useless. I think that I've read a few cases earlier, and I think that Massachusetts courts read statutory and regulatory text to give every word an operative function. And where a reasonable alternative reading is available, and the commissioner's interpretation, that attic refers to any top floor space within the roof line of the structure, whether finished or not, gives the exclusion real, continuing meaning consistent with how the term functions elsewhere in the same bylaw. So as much as we may not like that, it's going to be built out, it may have 5 occupants or many occupants, my position is to support Commissioner Moore's position. And I know that I think I know that Mrs. Silver, Mr. Meadows, and I think Ms. Morton is against that position. I am for that position. Mr. Offeld, I don't know, because we need 4 out of 5 to override Mr. Moore.
Mr. Chair.
Yes, Mr. Offeld.
Yes, with the information I have right today, I would support Mr. Moore's decision. Again, it's not and it's based on my understanding that what our job is as the ZBA is to interpret the bylaw as it exists, not as we wish it would exist. And I don't see any misinterpretation by Mr. Mora. I'm looking at the definition. I've heard the numbers tonight, and it appears that he has properly applied those definitions. So I don't see any error on his part that needs correction by us.
I am of that position. Mrs. Silver?
I almost hesitate to say anything because it looks fairly clear, but I would like to make 2 brief points. One is that I believe that we are charged with protecting the residents of this town, not interpreting exact state laws. There are attorneys to do that. I believe that we are selected by the members of this community to look out for them and to use our common sense. So I would just like to reinforce the point that we each have votes that we can exercise based on what makes sense to us. And I think that's really important. The other thing is that I think that failing to go on record challenging a definition that makes absolutely no sense sets a bad precedent for the town and for the ZBA. So I understand the chair and Mr. Offeld's positions. I respect both of you greatly. I know that you make these decisions with integrity and commitment. I think there are other factors involved here that we need to take into consideration. Thank you, Mr. Chair, for hearing me out. I appreciate it.
Thank you, Mr. Slover. Mr. Meadows?
I feel very similarly to David, that the charge that we have in our ZBA requirements is that we are to look after the benefits of the town and the people in the town. The suggestion that Michael Pill made that it doesn't make any difference if the children are walking down the street. We're not here to protect children, and that the laws of the state don't protect children in that way. I don't feel that way at all. I feel we need to protect the town. We need to protect the occupants of the town, the people that live here, that vote here, and that expect us to do something that is reasonable. Now, I understand where Mr. Moore is coming from. He's trying to follow some contorted definitions. But the definitions become contorted as a result of not the thought that you're considering, Mr. Henry, but by people not thinking. If it weren't our job to make interpretations every time that we gather as a ZBA, then there's no reason for us to be here. We have to make decisions based upon how we see that decision affecting the people that live in this town. I've been here for over 50 years. I've seen a lot of different ways that things are interpreted. But it is usually to the benefit of the people of the town, not to try and stick with a definition that the state pushes down on us or that was mistakenly put into our town bylaws, because I know it was a mistake, having talked to some of our town councilors. It perhaps is up to the attorneys in the long run to make a decision, but it's up to us tonight to make a decision to the benefit of the town.
Thank you, Mr. Meadows. My response to that would be, I wholeheartedly agree with you and Mr. Sloter in that we are charged to protect the town of Amherst. And I would suggest that the position that I'm taking with Mr. Offeld is in concert with that. It's our decision to say that the bylaw as written is meant to be interpreted. I would say that if we take the position to redefine what an attic is, then we may have other applicants come before us with similar things to say, this word makes no sense. You guys need to change this. We are not charged with changing the bylaw. That is town council. And I think that was said by a lot of people as applicants, arguably in some public comments, that if there is an issue with the text and the language of the bylaw, then it needs to go back to town council for them to modify that. But until that happens, we need to act within the confines of such bylaw. So Mr. Kuhn argues the exclusion common thread is ancillary, non-primary living space. So attics must mean only unfinished space. But the common thread, I would say, among crawl spaces, garage parking areas, and enclosed porches is not habitability. Enclosed porches are frequently finished, as you heard from Mr. Sloviter, heated, used as a living space, yet are excluded regardless. The better common thread is location and building form. Each excluded category sits outside the building's primary living floor envelope, below grade, within a grade bay, in an attached appendage, or under the roof line, not a habitability test. And I think that's what Mr. Kuhn is asking for here. So if we read the bylaw that way, attic fits the same pattern as enclosed porches, excluded by location and construction type, not by whether it is finished. So even though the intent here is to add all this living space in the attic, and one of the questions I ask Mr. Mora is, if it is built out, does not change the definition? And under the bylaw, it does not. And I think as much as we may argue or disagree that, it's going to change the fabric of the neighborhood, and I submit it absolutely will, that is not what the question is before us. And I yield to Ms. Morton.
Thank you. The taking into account enclosed porches are only a 3-season space. They are not a fully occupied space like what we're talking about on the second floor of this building. The second floor of this building is a year-round space. And so I would say that those are not, those can't be held as being the same type of space. Same thing with a garage. You don't live in your garage, you park your car in your garage. So I don't see that those are the same thing. And the intent of the 900 square feet for these ADUs is that they should be not more than 900 square feet, not that, oh, well, if somebody builds out space in their attic, we don't have to count that. I would say the attic is the second floor and not the attic, and it is usable space and therefore needs to be counted. Thank you.
Mrs. Sloviter.
An enclosed porch, a garage, other things like that do not increase the number of occupants in a building. They are shared by the occupants. The number of bedrooms determine the number of occupants. But that said, I would be in favor of not continuing to go around on this. I think we're all clear. And while I am intensely displeased, I would like to call for a vote and move on.
Thank you, Mr. Meadows.
No, Sloviter. Meadows.
I'm sorry.
Meadows is the good-looking one at the bottom of the screen.
I'm the older one.
Barely.
Thank you, Mrs. Sloviter. So I think it seems that we have, and I will put this out there. I am comfortable taking more time to review, and if there's anything that changes my mind, but my vote tonight would be to support Mr. Mora. So if we are going to have a vote on this appeal, and I will give people options. So if it's an up or no, we can do an up or down vote and resolve it tonight, or we can take things away and contemplate and just come back to a public meeting and make a decision? Mr. Sloboda?
Well, if that is possible, and you would like the opportunity to review and think about this, and if Mr. Offel would like to read the rest of the application that he hasn't had a chance to read yet, then I will be happy to change my position of let's vote tonight and let's put it off to a date certain if gathering more information will be productive. So do you want me to make a motion that we do that? I don't know what you want.
Yes, Mr. Sloboda. So I would entertain a motion to continue this to a date certain for a public meeting. Is there such a motion?
So moved.
Second.
Before we do that, I see Mr. Bag's hand.
Sorry, I think it's just a process question. So I didn't mean to interrupt, and I don't know the right time to ask this, but if you're proposing to continue this to a date certain, can you just clarify how you, as a board, handle the public hearing portion and whether you're accepting new information? Because I do want absolute clarity of whether you're continuing a public meeting would be no additional new information is submitted, or it's a continued public hearing and you're going to get continued information. I would like clarity as to how you normally handle that. I haven't sat with you guys for very long. So if you can clarify that as you talk about continuation. Thanks.
We did keep the public hearing open, but the intent is to not relitigate. It's to go into a public meeting when we reconvene. So I wouldn't accept additional submissions. We have a multitude of information already. I think, just go through, digest. If there is, I don't necessarily think that we should take new information because then that could open the floodgates. Go ahead, Mr. Bag.
Great. So I just wanted to be clear that, I think my advice would be that the public hearing is closed and you're continuing the public meeting portion of this to another date. I just want to be super clear because we have to communicate with a bunch of people who have interest in this. So I know that you probably handled it a little bit differently. I just want to be as clear as possible that you don't want it, like the board is no longer accepting written testimony of any kind as you move to the next meeting.
I can revise my motion if that will help you.
Go ahead, Mr. Sloboda.
I move that we close the public hearing and continue continue the public meeting to a date certain, most likely
August 13th.
August 13, the next time we have a scheduled meeting.
Yes. Is there a second to that motion?
Second.
Second.
Any discussion? With no discussion, the vote occurs on the motion to close the public hearing and continue the public meeting to a date certain of August 13. Ms. Morton? The vote occurs.
Sorry. Yes.
Mr. Offeld?
Aye.
Mr. Sloboda?
Aye.
Mr. Meadows?
Aye.
And the chair votes aye. ZBA FY 2026-1927 Newell Court is hereby continued to a public meeting to a date certain August 13th, 2026. And let's put that first on the agenda at 6 p.m., Mr. Bag.
Got it.
Thank you. Thank you everyone for participating, and I appreciate if this may not be the decision you want to hear tonight, but I think continuing it allows it to be fair for everyone. And so thank you for your patience while we work through this. Our second order of business tonight, and before I bring them in, thank them very much for their patience, is ZBA FY 2026-21 112 to 114 North Witness Street, which has been continued from July 9th, request for a special permit for change of use from a 4 units building to a non-owner occupied duplex under section 3.3211, non-owner occupied duplex, an expansion of pre-existing non-conforming structure by enclosing an existing front porch under section 9.22. I know we continue this, as I said, from July 9th. And again, Attorney Bobrowski, Ms. Gu, thank you very much for your patience. This is a very long night, not just for us, but for you as well. Being respectful of your times and our times, I propose that we have this public hearing and we continue the public meeting to a different date certain. That way we're not here till 10 o'clock. So I don't want to kick this again, but I want you guys to have your hearing. So Attorney Bobrowski, Ms. Gu, just bear with me. I do have to go through the submissions. And so just give me an opportunity to pull up. So on this application for North Whitney, the submissions dated May 11th, May 28th, and July 17th. For the ones that I do not read into the record, they can be viewed on the town website under the document submissions. We have a cover letter, the special permit application, the sample lease agreement, application form, complaint response plan, site plan prepared by Berkshire Design Group, existing building plans, proposed building plans. May 28th, we have the cover letter, special permit application, sample lease agreement, application form, complaint response plan form, site plan prepared by Berkshire Design, existing building plans, proposed building plans, and as of July 17th, we have an updated cover letter by Paul Bobrowski, renter property management agreement with Hampshire Property Management, residential lease agreement, elevations, first floor, second floor, foundation plan, and cross-section prepared by Laura's Home Drafting and Design, site plan layout prepared by Berkshire Design Group. There are no staff submissions. We previously had a site visit on July 7th. There was not one this week. In terms of permit history, it was initial special permit ZBA FY 1957-1 and for porch renovation in ZBA FY 1987-22. Attorney Bobrowski, Ms. Gu, welcome. The floor is yours.
Thank you, Mr. Chair and the ZBA. It's been a long night already. I appreciate you hearing us tonight. What I was hoping to do, if I may, would be to do a quick summary, 30 seconds or so, and then go into the various aspects of the proposal. Hopefully that'll accelerate your knowledge and eliminate some questions. If that's agreeable, I will begin. So this, I think you know, this is a plan to convert a lawful 4-unit building into 2 vertically organized duplex residences, coupled with physical rehabilitation, removal of obsolete apartment circulation, improved private outdoor areas, a continuous party wall separation, organized parking, and professional management. The plan preserves the existing building footprint, the roof form, the height, and overall residential scale. It does not add floor area to the principal building or increase lot coverage. The internal work removes 2 kitchens, reorganizes the building into 2 side-by-side vertically connected homes identified on the plans as Unit A and B. Each unit has its own front entrance, internal stairs, first floor living space, second floor sleeping area, basement access, laundry, furnace, and electrical service. The plans remove obsolete exterior apartment circulation at the rear, separate the rear decks, enlarge the usable deck areas, and provide new stairs to grade. The front covered porch is rehabilitated as 2 3-season porch areas within the existing porch roof and footprint. The existing structure is retained and reinforced as needed. The plans also show a continuous central party wall concept from basement through the upper floors, with a type X gypsum board indicated on both sides, subject to final building commissioner and fire department review. It formalizes 4 9-foot by 18-foot parking spaces, 2 on each side of the building, while retaining the existing building and mature site character. If we look at the site plan, there are 4 formal off-street spaces shown, and they're approximately 9 feet by 18 feet. The building footprint, as I mentioned, remains unchanged. That's the principal building footprint. The plan notes a new rehabilitated porch and landscaping, but shows no enlargements. Moving on to the exterior elevations in the front, the existing front roof and porch roof remain. The proposal works within the existing porch footprint. The former open covered porch is divided into 2 3-season porch areas, 1 for each unit, by adding exterior walls and windows where railings presently exist. The existing concrete columns and framing are to remain and be reinforced as needed. The existing central front stairs remain and are repaired as needed. The front facade remains symmetrical and residential in character, with separate Unit A and Unit B porch areas rather than multiple unrelated apartment entrances. In the rear and side elevations, the existing covered rear porch roofs remain. Each rear deck is extended outward by approximately 5 feet, increasing the depth from approximately 5 feet to 10 feet. The existing connection between the 2 rear decks is removed, creating 2 distinct outdoor areas rather than a shared circulation platform. New stairs to grade are provided, improving direct access from each unit's rear deck. The existing upper level rear door and landing are removed and replaced with a bathroom window, eliminating obsolete exterior access associated with the former apartment arrangement. Moving on to the inside, the first floor plan is divided into 2 mirrored side-by-side units, A and B, around a central party wall. Each unit has a separate front entrance through its own 3-season porch area. Each unit contains a first floor bedroom at the front, a living room, dining area, kitchen at the rear, and a full bathroom near the rear center. Existing interior walls are selectively removed to open the living dining arrangement and create a more coherent family scale floor plan. The existing kitchens remain in the rear first floor locations, but are reconfigured as part of the new layout. The 2 former upper floor kitchens are removed. Each unit has its own internal stair near the center of the building, connecting the basement, the first floor, and the second floor without reliance on exterior apartment stairs. The first floor rear door opens to that unit's covered porch deck area. Smoke detector and combination carbon monoxide smoke detector locations are indicated on the plan, subject to final code review. Second floor, each unit contains 3 labeled bedrooms on the upper level, producing 4 bedrooms per duplex unit when combined with the first floor bedroom. Each unit has 1 existing full bathroom on this level. The former upper floor kitchens are removed. The former rear exterior door and steps are removed. A new window replaces the central rear door opening. Smoke and combination carbon monoxide detectors are also shown in the bedroom and circulation areas, again, subject to final life safety design approval. The central wall, the party wall treatment, continues up through this level. Down to the basement is divided into 2 sides by a new central party wall aligned with the division above. Each unit retains its own internal basement stair directly below its first floor stair. Each side has its own laundry area with washer and dryer locations. Each side has a furnace, reinforcing separate operation of the 2 dwelling units. The plan shows an existing electrical panel on one side and a new electrical panel on the other. Existing basement exterior doors remain on the side walls, providing service and maintenance access. just coming down to conclude here, we feel this plan reduces the intensity of the location from 4 independent units and 4 kitchens down to 2 units and 2 kitchens. There's no expansion of the principal building. Improved unit organization for each unit functions vertically with its own entrance, internal stairs, living area, bedrooms, etc. We also remove the obsolete apartment features, upper kitchens, exterior doors, etc. The appearance to the neighborhood would be improved as well. The rehabilitated front porch, new windows, walls within the porch, repaired structure, landscaping, and organized parking. Most importantly, there is improved accountability. The physical plan aligns with professional management, lease enforcement, parking enforcement, and routine inspection commitments already before the board. That's all I have. Happy to take questions, and so is Ms. Gu. I've also want to note that Jeff Squire from Berkshire Design had a family commitment. I've texted him, and if he's available, he'll join the meeting as well. Thank you.
Thank you, Mr. Bobrowski. I just have one question. Can you clarify what no changes to the exterior of the building means, given that the porch, the stairway removal, the deck work, and street-facing landscaping already described? Is this different building exterior from site work? Because I think I read somewhere says no changes to the exterior, but all the things I just said constitute a change to the exterior. Can you help me understand what that means?
Yeah,
No change?
the language is loose. I admit that. I guess what we are trying to say there is that there's no reconstruction there except removing elements that apply to the 4 apartment units versus the 2 that we're proposing here. So we don't need those exterior stairs. We want to separate the decks to make them more private for the 2 units, etc. But in terms of coverage, for example, there's no change.
Okay. Thank you. Mr. Bagg,
Sorry, I did want to just try to clarify because there could have been something in the project application report that was intended to connotate that no expansion of the footprint of the building was proposed, and I think that's relative to that it's non-conforming. And so we did want to just identify that the footprint itself is not expanding. So there are some exterior changes, but the footprint was, I don't know yet if that was in the project application report. I just wanted to try to clarify that footprint is not expanding, which was pretty relevant to 9.22.
Okay, thank you. Do any members of the panel have any questions for Ms. Gu or Mr. Meadows? You're on mute.
Sorry. Are there landscaping changes that are anticipated? Often we have a landscaping plan.
There are not extensive landscaping plans, but certainly the applicant is willing to follow any conditions imposed by the board. We've already started in front of the front porch, ripping up old bushes there, and we'll do new plantings there. But of course, that's subject to any new conditions imposed by you folks. But applicant is certainly willing to follow those instructions.
Often we ask for pollinators to be planted. If you're doing new plantings.
Sounds good to me.
Thank you, Mr. Meadows. Ms. Morton?
Regarding the parking, the plan that was submitted originally wasn't very clear on the parking, and I noticed that the new one does have a more clear parking layout. Is that going to be paved parking, or is that some other type of parking?
It will be paved.
paved. Okay,
Yes.
thank you.
Yeah, we've gone, just be honest, we've gone back and forth about the parking in terms of number of parking spaces. I know that the board, based on, I think it's section 7 of the bylaw, has some discretion there. We have an alternate plan that shows 3 spaces as well, but we went with this one for now.
Okay, thank you.
Thank you, Ms. Morton. Mr. Offeld?
Two little things. First of all, on the PAR, maybe this is a note to Mr. Bagg. Ms. Morton's name is not on there as a board member. And I think it's just a matter of catching up. I think the intention is that Ms. Morton is on this panel. But my more substantive question is, I was looking for a complaint response form, and I'm not sure I can find the most recent one. The one that I could find still refers to Tristan Doyle as the person responding, and would it be instead the property manager,
It should be.
Meglioli?
Yeah, it should be the property.
Okay, I'm not sure we have the most up-to-date form then. Or maybe I couldn't find it. That's
If the board is interested or wants me to, I can summarize parking enforcement issues that we've addressed and the role of the property management company that's been contracted with. Happy to summarize that very quickly for you.
Yes, please. Thank you.
Sure. Let me just pull that up real quick. So on the professional management, it gives them clear authority to enforce occupancy, noise, trash, safety, property maintenance, and parking requirements. Any material violations, repeated rule violations, unlawful activity, damage, or interference with neighborhood quiet enjoyment constitute defaults. Violations can be documented, noticed, cured where appropriate, and pursued through lawful termination process if they continue. Parking is specifically controlled. Only registered, inspected, insured, operational passenger vehicles connected to the approved occupants may use the property. Storage, repairs, abandoned vehicles, lawn parking, blocked access, and leaking vehicles are prohibited. Guest parking is subject to the same limits. Tenants must move their vehicles for snow removal or maintenance, and unauthorized vehicles may be towed where permitted by law. Town-approved parking plan and any special permit conditions
It's 9 o'clock.
will be expressly incorporated into the lease.
Thank you, Mr. Bobrowski. Mrs. Sloboda, you have questions?
Actually, I have one comment more than anything, because I remember very clearly from the site visit everything that Mr. Bobrowski has mentioned, and I approve of all of it. The parking was an issue because the spaces were not wide enough, and they were parking on the grass. When we were there were 2 commercial-related vehicles, trailers, I think, were next to the house on both sides.
You are correct.
Will they be gone?
Yes.
Okay, so no, parking of commercial vehicles will not be permitted, correct?
Correct.
Okay. Just as a comment, it occurs to me that if they wanted, since it's a narrow street, if the homeowner, property owner, wanted a third parking space, it was right there. It just happened to be occupied by trailers. So your parking proposal is fine. If you wanted another off-street parking thing, I don't think it would be a problem. But I'm not designing your property for you. But I have no problem supporting this application. I think this is fine. Thank you.
Yeah, I would just make one final comment on the parking. If you're happy with the parking plan, great. There are 4 bedrooms in each unit. And so the occupants of each unit will have to figure out their parking with 2 spaces,
Okay.
presumably for each. But if you're open to 3 parking spaces per side of the house, if you look at some historical photos, I believe we've seen those in the I've seen those at least with Mr. Bagg. There was parking all the way along the house on each side, not just in the front. Back in the day, dirt roads, so to speak, dirt driveways. A three parking space arrangement on each side would involve stacking 2 cars and then have another one next to them. And maybe Mr. Bagg is sharing that. This is the one that's in the plan now.
Yeah, I apologize because I don't think I have access to the plan that shows the 3 per unit.
I do have that.
Okay.
If I can figure out how to share that, I will. Let me figure out where I put it. Here it is. Let me share. My share button went away. Here it is. Sorry. So that would be the 3 and 3 arrangement. So again, it would require some coordination, but it would give more assurance that there's space for the occupants.
Well, I only brought it up because we try to look out for the broader community, and
Sure.
that's a fairly narrow street. And having additional parking on the property that's properly done might take a bit of strain off of North Whitney Street. I don't actually care if there's 2 or 3. I'm just bringing up that I think your site plan is appropriate, and whichever way you go, I don't have a problem supporting it. Thanks.
Thank you.
Thank you, Mrs. Sloboda. Are there any additional questions for the applicant? Mr. Bagg?
Thanks. I don't know if that applied to me, but I just wanted to say that, this is a substantial improvement to the property, and it sounds like the board is acknowledging that. I think that's important. In working with the applicant, it's been good, and working with Mr. Bobrowski, we did encounter a question about the parking that we wanted to have this discussion with the board to understand what it's section 7.000, which clearly gives the board this discretion. And so we didn't really feel comfortable producing findings or talking about a condition on a plan until we had this discussion. I do recommend the board look at the 3 spaces per unit. It does help organize the property, and it's a little bit more in line with what might be expected. In order to do that, though, the board would have to grant a couple waivers, particularly parking in the front setback. So just acknowledging that in order to get that arrangement, the board would issue some waivers. And I just didn't get quite far enough to presume that the board would be comfortable with that. So, I did have a conversation with Mr. Bobrowski that a potential continuation for staff to produce the findings and conditions for the board to review at the next meeting would make some sense. But we wanted to make sure we had this conversation and understand if the board had any other issues. But again, I do commend the owner for really taking this pretty seriously. The level of investment that's going to go into this property is significant, and it would really, there are some findings that are required to acknowledge that going from 4 to 2 is actually a potential benefit. And so I just wanted to kind of acknowledge those couple things to understand where the board would want to go from here.
Thank you, Mr. Bagg. If there are no other questions or comments from the applicants, at this time, I would invite any members of the public who wishes to comment on this application tonight to do so. Members in the audience who wish to comment can do so by using the raise hand function. If you're on the telephone, I believe it is either *9 on the telephone. And given where we are for time, I am being strictly adherent to the 3 minutes.
Yep. So as you'll see, I promoted Bob Newcomb, who raised his hand. There's a couple other people in the audience that they haven't raised their hand yet. But Mr. Newcomb, you should be able to unmute and turn on your camera if you wish.
Hi. My name is Bob Newcomb. I live at 87 North Whitney Street. First off, I'm 100% behind this whole process being done. I think this is fabulous. That building definitely needs, a lot of work. So that's fine with me. However, my biggest concern is parking. And where we sit, there's 2 4-bedroom units. I do like the idea of that third spot to minimize the number of cars that are on the street. We also have another house at the corner of North Whitney and Clifton that's about to open with, I think there's 2 units in there. There's more cars coming onto that street. We live very close to Taylor Street, which is, through the last hearing, there's 2 ADUs that are about, well, one's about to open and the building is going up. That street, Taylor Street, if you've ever come down that, it's completely blocked with cars. North Whitney is a narrow street. There is not a lot of room, and cars come up very, very quickly up that street, up and down. It's a cut through to the back of UMass. You can get to the middle school and high school coming down through there. So it is definitely a concern of having a lot of cars on that street with those 2 units opening. We've also, neighbors have seen on Clifton in particular, students coming in, parking their car there for the day and walking down to the bus. And so the use of the neighborhood beyond just the residents is another issue. So the parking is the big concern. There's also no limit on which side of the street you can park on. There is no parking this side. And then we also have the hill down there, which comes up from the railroad tracks, which if cars are parked on the side of the road there, you can't see until you're at the top of the hill, or can't see cars going down. So parking is a huge issue potentially for this street, and that's my biggest concern. But I'm really happy that this work is being done on that house.
Thank you, Mr. Newcomb.
Thank you.
I don't see any. There's 3 other people in the audience, but they're not raising their hand, so I'm assuming they don't want to speak to this.
Seeing that there are no further public comments at this time, unless there's any further questions or any comments from the applicant, I would entertain a motion to continue to actually, rather in tandem, move to a public meeting while keeping the public hearing open, but continue the public meeting to a date certain, so we can go through the findings and the conditions appropriately.
So moved.
It has been moved. Is there a second?
Second.
It has been moved in second. Any discussion? No discussion. The vote occurs on the motion. Mrs. Sloviter?
Aye.
Mr. Offeld?
Aye.
Mr. Meadows?
Aye.
Ms. Morton?
Aye.
And the chair votes aye. The vote is 5-0. The public hearing, we are officially into a public meeting while keeping the public hearing open. However, we are continuing this public meeting to a date certain. And this is, I think we need to, I don't think we should put it on August 13th. I think with what we just continued, as well as what's coming up, there's already 2 other things on August 13th. And I think the applicants were made aware of that. So the next date would be the meeting after August 13. So with everyone here, is that a good date for this current panel? Which would be August 27. Would that work for all of us?
Yes.
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 I'm not certain.
I know.
Then it's not a date certain for you.
Yeah.
No, it's not a date certain. My son has to have an operation that day, and I don't know whether I've got to be, how late I'll be in Boston.
Would so the next date, I believe, after the 7th, I believe would be September 10th. I don't know if that's pushing it too far.
I'm not available September 10.
Okay. So, Mr. Bag, the items that are on for August 13th, in an effort not to push this too far, is there an opportunity to move one of those from August 13th to a further date that we haven't heard before?
I don't think so because we just legally advertised the two other hearings for August 13th. I would say that the board has the appeal, which you just continued with no new information coming in. So it's a decision-making discussion. The other two that are scheduled, I knock on wood, are relatively minor in theory. One is to extinguish a special permit that the use is now allowed by site plan review. So it's a formal process to just rid the property of the special permit. So in theory, that should be pretty straightforward. And the other is a change to a property on Northampton Street. It's in a larger apartment complex, but to change an on-site security guard requirement to an on-site manager. So it's a management type of project, not a large construction project or something like that. So I would argue that with the clarity that the board has given tonight, the cooperation of the applicant, I think we could draft findings and conditions for this for the 13th, and it should be relatively straightforward. So it sounds like a lot. There'd be 4 items on the agenda, but I think it would be potentially manageable.
I think we can with those descriptions of what's before us. So
Okay.
I think we continue to August 13.
Good.
Great.
Yeah. So
Good.
we're continuing ZBA FY 2026. I believe it is dash to 112 to 114 North Whitman Street to a date certain of August 13th.
Does that require a motion that you can't wait to hear?
No, I think we already did the motion we just didn't pick a date. Yeah.
Okay.
Yes.
Okay.
Yeah. So we already voted, and now it's official. The date certain is August 13th. Yeah. So with that, this is general public comment for any items not before the ZBA tonight. I'm sorry. Before we do that, Mr. Bobrowski, Ms. Gu, thank you for being here. This has been continued to our next meeting, which is August 13th. And at that will be a public meeting. It's an opportunity for the board to deliberate on your application. And as you heard, there are other things on before you. We did continue the previous one to 6 o'clock, which means yours will not start exactly at 6. So I don't necessarily think you have to be here right at 6. Yeah. Okay. But
Understood.
thank you again. Thank you for your patience and thank you for being here tonight. And we will see you on August 13th.
Very good. Thank you for your public service. Appreciate it.
Thank you. So back to our regular agenda. Are there any general public comments of anything not before the ZBA tonight? I don't know if we have anyone left in the audience.
Sorry,
Take-
I got lost in my Zoom screen there.
It's okay.
I was struggling for a second.
That's the quickest adjournment I remember.
Yeah.
There are 3 other people in the audience, but then none have raised their hand to speak for something that's not on the agenda.
I will accept that. Is there any other business not anticipated within the last 48 hours for us tonight? I do not believe that there is. And in traditional fashion, I know we just did a bit of this just now. Mr. Bagg, I know we just discussed the 23rd, but what do we have coming up?
Yep. So the 13th you
I'm sorry, the
discussed,
13th,
right?
yes.
The 27th, we do not have anything advertised, but we would potentially have, oh gosh, now I got to remember. There is a homeowner request to expand or alter a pre-existing non-conforming structure, and then we do probably have it's an appeal, so it's quasi-enforcement action, also a special permit to change from a owner-occupied duplex to a non-owner occupied duplex. We're working with the applicant to make sure that they have enough plans and information available, but that's slated for August 27th.
And there's an appeal as part of that, you said?
Yeah, it's ongoing discussion. The way that would work, the appeal is generally to preserve a right and access to a use, but the better path, and the applicant is agreeable, is to actually apply for the special permit to modify. We don't have all the paperwork in yet, and we haven't advertised it yet, but I think we're working on that for that meeting.
Okay.
So I apologize. I don't know if you normally have everything lined up. We're working,
We
kind of double time to keep up. The board is very busy. There are likely applications that are going to get queued up for September as well. So we're just trying to keep pace with some of this stuff.
That's okay. We usually don't have everything. We just said this may be coming up, this may be coming up. So you're fine. Yeah.
Perfect. Thanks.
So thank you for that. So with the time being 9:19, I will entertain a motion. Mr. Sloviter.
That this is not in the last 24 hours, and I don't want to be even more hated by prolonging this meeting, but I will not be available on September 10. So I'm giving you notice so you can line up one of the associates in my absence.
That's very helpful information. Thank you.
And you may want to contact both in case Mr. Meadows is also not here. Was that September 10, Mr. Meadows, or was that the week before?
No, that was the
Mr.
one
Meadows is the
before,
27th.
the 27th, and I think it'd probably be better to line somebody up since I may get stuck in Boston as I was the last time.
Okay.
Yeah, I would just say I would imagine it was relatively usual for you to get polled, and I can start to coordinate on the August 27th and just make sure we have an understanding of who's available, who needs to be on the panel. And I'll do the 27th of August with September 10th together just to make sure we have panel for those dates.
Okay.
If I may suggest, if they're given that if they are both available on both dates, I would suggest we give one date and the other for the experience. Yeah.
Okay.
Yeah.
I can do that. And Stephen McCarthy, who's in the Conservation and Development Office, will be stepping in a little bit more. I'll be stepping back a little bit, but we'll be coordinating. But I think he's much more available for the August dates and the September dates. So we'll be shifting a little bit of the responsibilities around.
Understood, and thank you. So with that, I would entertain a motion to adjourn tonight's meeting at 9:21 p.m. Is there such a motion?
So moved.
Second.
Is it moved as a second? It has been moved in second. The motion is not debatable. The vote occurs. It just requires a roll call vote. Ms. Morton,
Aye.
Mr. Meadows,
Aye.
Mrs. Sloviter,
Aye.
Mr. Offeld,
Aye.
and the chair votes aye. The vote is 5-0. Thank you all for your service. We are adjourned.
Good night, everyone.
Good night.
It's interesting that we're now back to we used to go through 9:20, 10 o'clock every week, every meeting. So we can get used to that again.
But only if we must. Okay.
Yes.
And best of luck to your son.
Yes.
Craig.
Thank you.
Yeah.
Thank you. Good night.
Good
Got
night.
it.